They changed it to tomorrow, y'all. They changed it to tomorrow. I had it written down for today. The judge said Wednesday. Today's Wednesday. Last night when I looked, it said today. Court TV now says it's tomorrow. So we don't have a sentencing today. We have it tomorrow. Yeah. Yeah. So I don't know what to do. I guess we can watch Bardo, and then I can change the description and the title and all of that. You want to do that? Guess we can do that. Man, it ticks me off. I was all excited. Man, that sucks. Wait. Oh no, we're not on part 13. Good, we're on part 14.
In a way that was not nasty, yes.
All right.
Well, Doctor, what about the way she said them just now? Do you think that's nasty?
You haven't figured out
particularly.
that I'm not good at this stuff yet, Marty?
And now he told you also that he brought the gun because he thought he was going to have to shoot through the security guards, correct?
There was a time he said that, yes.
And you are aware that he never said that to anyone before you.
Right.
Did you discuss that inconsistency with him?
No.
Now, after the first visit when he saw Rebecca Schaeffer, obviously then he had seen that there was no security to shoot through, correct?
Correct.
So when he went back the second time, this time with the gun fully loaded, did you ask him why he brought the gun with him in a fully loaded condition if it was not for the purpose of shooting through security as he told you?
Well, he had told me how the gun got in that condition, and I assumed he wasn't going to throw it in a wastebasket or otherwise dispose of it.
Or maybe just hide it somewhere? Or maybe put it in a locker somewhere? Did you ask him any of those questions?
No.
Doctor, did you ever ask the defendant if he considered the possibility that she would not open the door to him a second time if she saw him through that glass door?
No, he described to me something along those lines. I didn't have occasion to ask him about it.
And what was it he described to you along those lines?
He said that he thought she wasn't going to answer the second time because he rang repeatedly and didn't get a response, and that he was about to give up. And
I didn't know that, Carla. That makes him an even worse. I can't even talk today. An even worse selection to use to collect evidence in the snow. Oh, that's funny.
leave, and then suddenly she appeared. So I took that to mean that had she not come at all, he would have left.
My question was whether you asked the defendant if he considered the possibility that she might not come out if she saw him standing at the front door the second time.
I did not.
And did you ever consider that possibility?
Yes, I did.
And rejected it?
No.
If you did not reject it, doctor, then you considered the possibility that in going back the second time, he rang the doorbell and stood away from the door and waited for her to exit the door and then shot her?
That's one of the two things that I thought could have happened.
And I take it by the conclusions you've given us that you rejected it.
I'm sorry, I must have lost you on something here. Could you tell me where we are with this questioning? Because I thought you were saying what would have happened if she hadn't opened the door but did show herself.
No. I'll tell you what, let me come back to that later. Did you ever ask the defendant if at the second visit, let me ask it this way. Did you ask the defendant whether, if at the second visit he prepared for the possibility that she would not come to the door the second time if she saw him by stepping off to the side after he rang the bell? Did you ask him that?
No.
Did you ever ask him why he brought the Joshua Tree tape, the one he said he listened to when he said he was feeling animosity for Rebecca Schaeffer?
It was a CD.
CD, sorry.
Yes.
Now, you recall him telling you that he listened to it for comfort when he felt animosity for Rebecca Schaeffer.
He listened to it for many things, including that.
Do you remember him telling you that specifically?
Yes.
And when he told you that bringing the book Catcher in the Rye was insignificant and it was just a convenient way to carry the postcard, did you ask him why then he'd put it on his list of things to carry?
No, I knew he was lying to me about that.
You knew he lied to you there?
Yes.
And did you consider it significant at all in terms of your ultimate conclusion in this case that he lied to you about that reason for bringing the book?
Significant. I do expect defendants to lie to me, and sometimes about central things, sometimes about peripheral things. It's something I try to take into account and that I'm aware of.
Mm-hmm. And that's another reason, of course, why you look for independent corroboration as to statements that are made that seem to be self-serving on central issues, correct?
Yes.
And although you did not find any in this case, and now you're telling me that you know the defendant lied to you about something, notably about the book that he brought with him, you still believed his self-serving, uncorroborated statements about central issues?
On some of them, yes.
All right. Now, in fact, that bringing that book, Catcher in the Rye, is fairly significant in that it seems to copy not only Chapman, another assassin, but John Hinckley.
Object to the form of the question of characterizing assassin, using that characterization. It's argumentative, it's a legal conclusion.
It sort of is a legal conclusion in the context of this case. Obviously, Mr. Chapman was an assassin. One of the things we're here to try is the mental state of the defendant. So I think it's a question that I'll allow if you strike the word another.
Would you agree, Doctor, that it is fairly significant in terms of the defendant's intent in going to Los Angeles on July 18th, that he brought the book Catcher in the Rye, which had been carried by Mark David Chapman when he murdered John Lennon, and had been carried also by John Hinckley when he attempted to murder President Reagan?
Well, the answer is yes, but Mr. Bardo indicated to me that he didn't know that Hinckley had had that book with him when, in his hotel room, because he appeared genuinely surprised when I told him that.
But he did know, of course, about Mark David Chapman.
Yes, that's why he bought the book.
All right. And isn't that why he carried the book?
I think so, yes.
So do you not believe, sir, that in carrying the book Catcher in the Rye, the Joshua Tree tape that he told you on the video tape was something he listened to when he felt animosity for Rebecca Schaeffer, the gun on which he at least proposed to scratch off the serial number, and the bullets that he had prepared for himself an assassin's kit?
That's exactly what I think.
And he told you that he went to kill Rebecca Schaeffer, but that was not his sole purpose. However, he told Los Angeles police that he went to Los Angeles for the purpose of waiting outside so that he could shoot her on her way in or out of her apartment. You recall that?
Well, I recall his saying that that's what he was planning to do. I don't know if he said that that's why he traveled to Los Angeles or at what point he planned to do that. But he made it plain to them that he was traveling to Los Angeles to kill her.
All right. And that there were no alternatives given in his plans to LAPD, were there?
I don't see any in the report.
However, to you, he said that there was an alternative and there was a purpose that did not involve killing Rebecca Schaeffer.
That's the last statement, because it's clear from the police report statements that there are statements purportedly made by him which indicated the alternative, that he wanted to hurt her and he did not want to hurt her. And I direct the court's attention to page 7 at the top.
Page 7.
Where there, of course, I think you have a typed version. The page 7.
On page 7.
And I'll read that. There's
Go ahead.
a line that says, "There was confusion in my mind. I wanted to hurt her, but then I didn't want to hurt her."
That's not what I'm talking about, Your Honor. He's on a completely different subject. I'm talking about his plan when he left Tucson to come to Los Angeles. And the defendant does address that farther down. As the court is aware, we've gone over this statement yesterday.
Yep. Well, why don't you rephrase the question? I'll sustain the objection as phrased. I think the subject matter is a legitimate area of inquiry, but there are at least the statements from which it could be inferred that he also wanted to see her, etc. I mean, I have never seen anyone who ever did anything in my life with a single motive. So you may explore thoroughly his motives, okay?
I'm just going to read this statement to you, the one we read yesterday from the police report. When I went to Rebecca's, I planned to wait for her and shoot her as she came out or went in. You recall that statement?
Yes.
The statement that Mr. Galindo referred to indicated that when he finally, I'll read it. Let me quote it. When she came down the hallway, I wasn't prepared. There was confusion in my mind. I wanted to hurt her, but then I didn't want to hurt her. At first, I wanted to shoot her because I was jealous of her scene in class struggle with Ray Sharkey. I went there to kill her and even took a copy of Catcher in the Rye in the bag, like Mark David Chapman did when he killed John Lennon. I had gone to New York City in April 1988 and visited the Dakota apartment building to see how the security was. When I went to Rebecca's, I planned to wait for her and shoot her as she came out or went in. From that statement, Doctor, may we infer that when the defendant left his home in Tucson, it was with the plan to kill Rebecca Schaeffer while waiting outside and shoot her as she either went in or out of the apartment.
Yes.
May we also then infer from that statement that it was at the moment he saw her that he claims to have had confusion about what he should do?
Yes.
Well, we can infer, Doctor, that this statement then does not give a dual motive for going to Los Angeles, but merely expresses hesitation upon seeing her after he had already gotten there. As far as the statement is concerned, that's all I'm talking about.
That's right.
All right. Do you have a lot of cross yet? All right, then we'll take the noon recess. I have another case I have to handle now. All right, let's make it 140, but a very firm 140. Okay, I expect all parties here at that time. As soon as this defendant is gone, Mr. Green, would you come forward with your client? I saw Mr. Munzberg walk in. Oh, there he is.
Now, we were talking about the statement that the defendant made to Los Angeles Police Department, Doctor. Do you recall reading the part where the defendant said that he had first become interested in guns after reading about the Patrick Purdy incident, the young man who went to a schoolyard in Stockton and killed 5 school children?
He said that's when he first became fascinated, yes.
Did you ask him what it was about the murder of innocent children that made him excited about getting a gun?
He didn't say he was excited about getting a gun. He said he became fascinated. I didn't ask him about that statement because I didn't receive the LAPD report until after I'd already examined him.
Tell me what you make of that now.
I make of it that he, like Joseph Westbecker in Louisville, decided to emulate in part a mass murderer who became a media figure through Time magazine. And that like other assassins and like others who have done mass murders, he's very responsive to what he sees in the press, very much influenced by it.
Is that out of a desire to get in the press himself?
Well, only in part, Your Honor. It's also a desire to identify with powerful people or people who are treated specially or people whose rage is recognized. It's many things simultaneously, but there's no question that the media fuels it greatly.
So in part then, it's a desire for fame and notoriety to be achieved by a high publicity crime. Would you agree?
That's in part his motivation, that's right.
And might it not also show that in buying the gun, his express purpose was to use it in a murder?
His express purpose?
Well, let me rephrase that. Might it not also indicate that part of the motivation that went into buying the gun for him was for the purpose, ultimately, of committing murder?
Yes.
Now, in light of the fact that in 1984, he said he identified with John Hinckley, and then in 87, he said he identified with Mark David Chapman, and then in 89, he read the story on Arthur Jackson, and then he told Los Angeles Police Department that Patrick Purdy's massacre got him interested in or fascinated with guns, and that he said he'd fantasized many, many times how he'd kill Rebecca Schaeffer. Did that give you some idea that he made a career choice to become an assassin himself?
Career choice might not be the ideal way to capture it, but I think that there's a lot of truth to that view as well.
That he was aiming towards becoming an assassin himself?
Yes.
Now, the defendant told you that on the second visit, when he went back, he grabbed the door away from Rebecca Schaeffer and that she just stood there staring at the bag and she didn't panic. Doctor, consider the fact that at the first visit, Rebecca Schaeffer had told the defendant not to come back. She behaved cautiously. Now he's back, just a half an hour later. She's wearing nothing but a short robe. She can't see well because she's not wearing her glasses. And the defendant claims that when he grabbed the door away from her, she just stood there. She didn't run, she didn't scream, and she didn't call for help. Did that description of events appear just a little contradictory and a little illogical to you?
I don't recall his saying she just stood there. I've got several different accounts of those moments. So I'll need to look at precisely which one you're referring to.
I believe that I'm referring to the first videotape. Let's see if I can find.
That's the one that was played in court, of course.
Yes. And I've seen them both, so I'm not sure which one I'm referring to. Are you looking through your notes for the first day, Doctor? For the first videotape? Okay, and I'll look through the notes for the second one. Okay, it's the second tape. Doctor, I'll show you a copy of your notes. It's not a number of pages, it's a fine copy. Let me read the notes aloud so that we're oriented. See, when I opened the door and all, she just stood there. She was just looking at the bag. She didn't panic when I grabbed the door from her. She just stood back a little and she was just looking to see what I had in the bag, as if I was giving her something, you know? Okay?
Right.
Okay. So it would appear in that account that he's saying that he grabbed the door away from her and she just stood there looking at the bag.
Yes.
Okay. Did you believe that?
I believe that he took the door from her and that she stood there looking at the bag, yes.
It did not appear to you somewhat illogical that having had the door grabbed away from her, she would stand there and just look as opposed to running, screaming, doing something?
It depends on how it was done. If he grabbed it and pulled it violently or threw her off balance, of course I'd expect her to respond as soon as she were able. But if he simply pulled it when she was struggling with it to ease her burden, then I wouldn't expect her to do anything.
What about that passage indicates to you that he was easing her burden?
Nothing indicates one way or the other which it was, but I could see him using the term grab the door to refer to having reached out and pulled the door gently.
No matter how he pulled it, Doctor, given the condition she was in, given the fact that she did ask him not to come back, that she behaved cautiously the first time.
That states the evidence, and this has been misstated before. I believe the statement was that she had asked to not come to the front door or didn't like people coming to the front door, not specifically that she asked Robert Bardo to not come again to her front door. Or
Let me interpret your question in terms, I don't expect when people cross-examine that they iterate statements verbatim. I understand what he said.
And I understand that's why I haven't.
That's the sense I'm taking it in. This is a court trial. I'm not going to adopt her statement in view of what I heard the evidence is, but it's a convenient shorthand way of referring to what she said to him, according to the defendant on the first visit. I'd rather you not come back to my door or something to that effect, and I'll get the exact wording.
In any event, she indicated at the earlier visit that she preferred that he not come back to her front door. She was behaving cautiously by his account. She's standing there now in a short robe with nothing under it and no glasses on. And this stranger, with whom she behaved cautiously the first time when she was fully dressed and wearing glasses, now pulls the door away from her. Did that not strike you as just a little odd that she would just stand there and stare at the bag and then engage in this argument with him that he describes?
Sure, it struck me as odd that she even came to the door either time.
Apart from that, sir, did that description of events not strike you as somewhat illogical? That she would just stand there and stare at the bag while he fumbled with it after he had grabbed the door away from her under the conditions I previously described?
I find it plausible if there was nothing threatening about what he describes as grabbing the door. I find it implausible if he violently swung the door outward.
And given, I guess, the fact that you cannot determine which way he grabbed the door from her, then you have no conclusion as to whether or not it was a reasonable or unreasonable description of events by the defendant.
I think I do know what he did because he showed me.
And what did he show you?
He demonstrated that he reached out and he pulled the door.
And given all that we have said about the prevailing conditions at the time, you do not believe it implausible that she would just stand there after he'd done that and look into his bag?
Well, I don't think she was actually looking into his bag. I don't think it's the case that she looked in and saw the gun. But I find it plausible that she didn't scream or run or do anything in the few instances that were available at that time.
Well, actually, the defendant then describes a conversation that they had. Do you recall that?
Right.
So it wasn't just that she stood there and stared at the bag or at him for a few seconds. She stood, looked at the bag, and they had an exchange for a period of time, did they not?
They did, by which time the perceived threat, if she felt threatened, would have now been undermined by his conversation.
If indeed it occurred.
That's right.
Let me ask you this. When the defendant gave a statement to LAPD indicating that he planned to go to Los Angeles, he planned to go to Rebecca's and wait for her and kill her as she either went in or out of her apartment, do you detect any note of ambivalence in that statement?
No.
And then if, as you when the defendant indicated to you, as I believe you stated yesterday, that he came to Los Angeles with the intention of having an interaction with her, and only as a result of that interaction would he shoot her, that is, if she were arrogant, you would agree that there is an inconsistency between the two statements, would you not?
If that's what he said to me, but I don't think that's exactly what he said to me. What he said to me was that he expected that she would be mean and arrogant and he'd kill her.
All right. And then we are inferring from that statement, I suppose, that meant there would be some interaction that could cause that reaction in her, correct?
Right, if you were to find her.
In any case, doctor, even based on the face of the statement he gave you, it is inconsistent with the one that he gave to Los Angeles Police Department about what he intended to do when he went to Los Angeles.
They are different. There are differences there. In both instances, he made it plain he came to Los Angeles to kill her.
One seems to contemplate interaction and one does not. Is that fair?
I can't play it on stream because it has music in it. I'll get copyrighted. I can type in what it says, but I can't play it.
That's
Characterization.
right.
If all of you guys would give me a way to message you on Messenger or Instagram, because I don't do Discord anymore, because I don't understand how it works, I could send you these things that I can send to Jill, Judy, and Wiggles. I don't have everybody's contact information. So it's your fault you can't see it.
Then to the extent that he led you to believe he expected to have interaction, Doctor, if he told the truth to the Los Angeles Police Department, then he lied to you.
No, it's possible to wait to shoot someone when they come out and also to converse with them in doing it. You know, after all, Arthur Jackson engaged in a conversation, however short, with Teresa Saldana before stabbing her. It is not incompatible.
Doctor, the import of the statement as I recall it to Los Angeles Police Department was that he planned to wait for her and shoot her as she went in or out of her apartment.
That's right.
All right. Does that not sound to you like someone who plans to kill from a distance?
Not necessarily.
Does that sound to you like someone who intends to engage in some meaningful interaction prior to shooting?
Meaningful to him only.
How do you read into that statement that he intends to have interaction with his target?
It isn't in the statement, but the statement leaves open the possibility that he would speak to her.
Where do you see that?
It doesn't say I would shoot her without speaking to her.
But it also doesn't say, Doctor, that I would shoot her if she were arrogant.
No, there's no contingency to it.
In other words, no matter how she looks in that statement, he's going to shoot her when he sees her, correct?
That's right.
In your situation, there is a contingency, isn't there? There's a condition preceding. She will be arrogant, therefore I will shoot her.
Yes,
That condition is not present in the statement he gave to Los Angeles Police, correct?
that's right.
Then if he told the truth to Los Angeles Police Department, he lied to you.
There is a difference, but not every difference is due to a lie. Perhaps he did lie to me.
Doctor, in general, claiming that an intentional killing was just an accident is an effort to minimize one's culpability, isn't it?
In general, that's correct.
And in general, lying about the location of a murder weapon, especially when a suspect claims that the killing was accidental, is also an effort to evade justice, is it not?
And I'm sorry to interrupt, but I think there's an important key point that needs to be made here. This phrase about that it was an accident, and we're referring not only to the LAPD report, but the Tucson report. I think it needs to be brought out that the term accident or accidentally was a term interjected by the police themselves and not Mr. Bardo.
Well, if Mr. Bardo made the statement in the LAPD police report that it happened in the way that the door bumped his left elbow and the gun went off, to me that is tantamount to an accident in the lay sense. Of course, you and I know that under the circumstances it would not be a legal accident, but it's different from an intentional killing. And that's the sense in which I'm taking. Okay? All right, proceed.
In general, Doctor, lying about the location of a murder weapon, especially when a suspect is claiming that the killing was accidental, is also an effort to evade justice, isn't it?
Yes,
And in general, offering a non-criminal explanation for carrying a loaded weapon is also an effort to minimize culpability, isn't it?
that one I'm not sure of. You mean in somebody who's committed a shooting crime? Yes,
Can a schizophrenic lie?
certainly.
Can a schizophrenic lie to minimize his culpability?
Yes,
And lying to the police is certainly not necessarily a sign of mental illness, is it?
no,
And lying to a psychiatrist is not necessarily a sign of mental illness, is it?
no,
And lying to minimize one's culpability is not necessarily a sign of mental illness, is it?
no.
Now, Doctor, if we assume for a moment that, in fact, the first visit did not go well at all, and that the defendant really felt extremely angry with Rebecca Schaeffer for being snobby and being arrogant and brushing him off, wouldn't you agree that that would tend to undermine your belief that he went back the second time with the primary purpose of having a pleasant and friendly visit?
I'm not sure I heard all that.
Should I repeat it?
Please.
Okay. If we assume for a moment that in fact the first visit did not go well at all, and that the defendant really felt extremely angry at Rebecca Schaeffer for having been snobby and arrogant and brushing him off at the first visit, wouldn't you agree that that would tend to undermine your belief that he went back the second time for the primary purpose of having a pleasant encounter?
Yes, it would.
Then would it change your opinion any as to whether he went back for the purpose of killing her?
Probably, yes.
And wouldn't you agree then that he went back Wouldn't you agree then, Doctor, that if he went back for the purpose of killing her because the first visit went badly, he might reasonably expect that she would not open the door to him if she saw him at the doorway the second time?
Yes.
In which case, would you agree that the evidence is consistent with the scenario that when he went back the second time, given all that we have assumed thus far, in order to get her to open the door and not to take the risk that she might go back to her apartment and call the police, the most reasonable explanation in light of all of the evidence is that after having rung the bell, the defendant would have hid out of sight and waited for her to come out of the door in order to kill her?
I see that that is possible. And if the assumption is that includes that he left there angry rather than joyous the first time.
Yes, it does.
Yes, I think that that's correct.
Okay. Now, as for the statement that he made to you concerning going back the second time to have a pleasant encounter, although there were some contrary indications given in his statement, reasons that you may have had to doubt that that was his primary expectation, yet he said that was his primary expectation and you did believe that he went back the second time expecting a pleasant encounter.
Yes.
Can you point to any independent corroborating evidence to support that?
I don't think there's any evidence one way or the other on it, independent of his statements.
Well, in fact, Doctor, there is some evidence that would tend to contradict what he says happened at the second visit, at the very least. Wouldn't you agree?
That's a different point, but yes, there is that.
All right. And what I'm getting at is, if indeed there is evidence that would tend to contradict his statement of the events as they occurred at the second visit, then perhaps his version of the event, his statement concerning what he expected when he went back the second time may also be in doubt. Wouldn't you agree?
All of this may be in doubt.
Okay. Let me ask.
Marcia, can we get off the second visit thing? I think we got it. I think it's pretty clear that she didn't expect him to come back. Can we move on, please? Please, can we move on?
Ask you this. There is some reason to doubt that he went back a second time expecting a pleasant encounter. In view of the statement that may have been made to Dr. Stahlberg. Do you recall that?
Yes.
I believe that we went over this a little bit yesterday. You indicated that you were not clear whether the defendant said he was thinking of killing Rebecca Schaeffer at the second visit to Dr. Stahlberg. And you were concerned about whether the defendant even said that. And you were concerned about whether he was telling the truth when he made that statement to Dr. Stahlberg. Is that a fair synopsis of what we discussed yesterday?
Yes, I think it is.
All right. Now, wouldn't you agree, Doctor, that the major concern in the course of your clinical assessment is whether you could rely on the defendant's statements to you.
That is a major concern, yes.
And particularly it is a major concern when there are self-serving statements made to you that are not susceptible of independent corroboration. Would you agree?
Yes.
So if you or someone else for the defense were to have called Dr. Stahlberg and found out that in fact the defendant did say that he was thinking about killing her when he went back the second time, then you would know for sure that he had either lied to you or to Dr. Stahlberg, rather than just being inaccurate in his recollection.
That's right.
And essentially, Dr. Stahlberg was with the defendant to do what you were with him to do, a clinical assessment of his mental state, correct?
I'll object to that. That misstates the evidence. That is not why Dr. Stahlberg was there. Dr. Stahlberg was there to do a 1368 analysis.
No, but
Doesn't that involve?
that may be true, but it doesn't misstate the evidence because there is no evidence as to why he was there before the court. I mean, it may be out there someplace, but again, I can only consider what happened here. But we can clarify this if that's what he was there for. I'll take your word for it.
If he was there for that reason, I don't know why he was there, Doctor, but if he was there for the purpose of doing a 1368, which is mental competence.
Yes, sir.
In that case, he would be engaging in a clinical assessment of the defendant's mental state, would he not?
At the time he was examining him,
Yes.
yes.
And if at the time he was examining him, it was very close to the time of the murder, it might coincidentally have some value in terms of his assessment of the defendant's mental state at the time of the murder as well.
That's right.
All right. And when you interviewed the defendant,
Are lawyers trained to to phrase questions strangely? Like, nobody ever asks a question and then ends it with, would he not? Like, wouldn't you say, wouldn't he? Like the one guy that we'd make a statement and go, true? Like, that guy bugged us all. And like, would it be fair to say, like, can you just ask a question like a normal person? Why do lawyers have to phrase things so strangely? I don't know. That's my squirrel for this 15 minutes. I'll have another one in like a little while. It's just weird. Talk like a human being. It's a college thing.
and it was also for the purpose of doing a clinical assessment concerning his mental state at the time of the murder, as best you could 2 years later, correct?
That's right.
And wouldn't you agree that the statement made to Dr. Stahlberg goes to the very guts of the case concerning the defendant's degree of criminal responsibility in this case?
I'll object. That calls for legal conclusion. There are many issues presented here, most notably the issue of mental state as required for lying in wait, as well as the mental state for premeditation and deliberation.
Well, Your Honor, except that counsel told this witness to investigate the issues of premeditation and deliberation and lying in wait, and it would appear that the witness at this point is pretty well familiar with what we mean by lying in wait and the critical issues in that regard.
Well, the only restriction on him giving a legal opinion is giving a legal opinion on the ultimate issue. There's no restriction on exploring the things that he had in mind when he was questioning the defendant, and I think that's what the question goes to. Am I correct, Ms. Clark, or
Yes.
not? Okay.
You examined this defendant, as you indicated earlier, Doctor, for the purpose of determining whether or not he had a mental state that was indicative of premeditation and deliberation or lying in wait at the time of the murder, were you not?
That's right.
All right. Then you realize, sir, that if the defendant made a statement indicating he went back to her door the second time with the intent to kill her, that's a critical issue, is it not?
Yes, it is.
All right. And wouldn't you agree then that the statement that he may have made to Dr. Stahlberg goes to the very guts of the case concerning the defendant's degree of criminal responsibility in this matter?
Yes.
And if you found out that the defendant did lie to Dr. Stahlberg on that critical matter, wouldn't that cause you to be concerned that the defendant was lying to you about the critical issues of what happened at that second visit?
I was already concerned about it, and that would not ease the concerns any.
It would probably aggravate them, would it not?
Sure.
And wouldn't the defendant's lying to Dr. Stahlberg be exactly the kind of thing that has caused you in your practice of forensic psychiatry in the past not to put much reliance on post-arrest statements taken from criminal defendants that have no independent corroboration?
Yes.
And in fact, you have no independent corroboration for what he said was his state of mind and expectations for that second visit.
That's
Oh, that was gross. He looked at his hand and then wiped it on his pants. Like, I guess he's picked his lip to where it bled before, I guess. And so he was looking, oh my God, that was disgusting. Cameraman, quit showing him picking his lips.
true.
Well, that's like in nursing school when, because like we would learn the book stuff in class, and then we had clinicals where we were working with nurses on the floor. Like our instructors would be there. If the instructors were watching us, we would do stuff like we learn it in school by the book. But then when the instructors weren't right there and we were with the nurses would be like, this is the way we really do it on the floor. Because you can't do everything exactly like the book says. There's not time. There's other ways to do stuff that are more common sense ways to do it, but it's still right. And it's still, with nurses, you have to do things sterile and clean, for the patient so you don't contaminate things, whatever. There's still ways to do it that way, that you don't have to go step by step by step by step like the books say. And the nurses will be like, okay, the instructor's gone. You can do it like this, and it works just the same way. Because the real world and the books are different. So yeah, you're absolutely right, Marty. There's more than one way to skin a cat. I don't like that expression. Why have I started using it?
In fact, Doctor, isn't it true that you have evidence that contradicts the defendant's statement about what transpired at the time of the second visit? In the form of, if not Dr. Stahlberg, since we do not know what the defendant actually said to him, Lynn Marta, when she testified that she heard no conversation prior to the shot.
That's correct.
And not only is it not corroborative, but it directly contradicts the defendant's assertion as to what transpired at the second visit. Wouldn't you agree?
Yes, I think it does.
And that contradiction, let me first ask you this. The defendant's statement to you concerning what happened at that second visit with respect to an argument is a pretty critical point in the case, is it not?
Yes, it is.
All right. So the fact that we have a witness whose testimony directly conflicts with what the defendant asserted happened at that point is a fairly important issue, is it not?
Yes.
Didn't it cause you to doubt the defendant's truthfulness in his statement to you about what transpired at that second visit?
Caused me to doubt each of their accuracy in recounting what had occurred.
Okay.
What do you mean by
And then,
In other words, of course, it caused me to wonder about the defendant's credibility, whether he was telling me the truth and so on. It also caused me to wonder as to whether Ms. Marta's sense of time about hearing the buzzer and the shot was accurate, and as to the threshold volume of conversation necessary for her to be able to perceive it from inside her apartment. And I don't have any information on the truth of that.
well, in rendering your opinion, sir, it appeared to me, correct me if I'm wrong, that you did believe the defendant's rendition of the events that transpired when he had the argument with Rebecca Schaeffer during the second visit.
Yes.
In which case you rejected the testimony of Lynn Marta.
Only with respect to how much time had elapsed and whether she could hear conversation had it occurred.
What do you mean by had it occurred? The defendant told you they had a conversation
That's
as
right.
a result of which he shot her,
That's right.
and you believe that conversation occurred.
Yes.
when she indicates then that the conversation did not occur and that the timing was such that none of what the defendant described could have occurred, you are saying that basically you have rejected the critical points at which their statements conflict. You have rejected her version.
Well, I objected her characterization that framing that the way that the witness had testified indicates that it could not have occurred, that type of language, because even the witness herself did not indicate that there was only one way that could have happened. My recollection was that the testimony by Lynn Martha stated that she thought when she was reconstructing the time sequence involved, she didn't speak in terms of absolutes, which is what the question phrased.
In terms of absolutes, she said she heard the buzzer, which is something she did not testify to before. However, she heard the buzzer and heard the victim leave her door, walk down the hall. She stated that she walked in a parallel fashion to her, and then she didn't hear the door open, but within a split second or a second of the last footfall, she heard the shot. That's pretty explicit evidence. And I see no confusion there, and if I'm mistaken, please point it out.
Yes, because since the court did consider her testimony at the preliminary hearing by stipulation, at the preliminary hearing she was not as certain as she was at the trial. She indicated it's in terms of seemed like, or she wasn't even sure she even heard the buzzer at her testimony.
Exactly, and I've already pointed that out. In fact, I said she didn't hear the buzzer.
And also there was a lot of testimony which conflicted, in our view, with her rendition here at trial.
Well, what is that testimony other than the things that you've pointed out?
Well, primarily what I did point out about the time it would
I've
seem
already
like.
acknowledged that. And but her testimony, as I heard it here, was very explicit. There's no doubt about the sequencing events. As a matter of fact, if she was testifying truthfully, she gives a very clear and coherent statement as to exactly what happened. That testimony is in direct contradiction to what the defendant said. Now, that doesn't mean one believes one or the other, but she's asking questions.
I was objecting to the framing of the question, but I'll withdraw it.
Well, let's hear the question again, and let's. I don't want to dissuade you from doing your job. Could we have the question read back? There was, as he's looking for it, there was, well, this needs to be on the record. He can't look at it and type at the same time, so I will wait. You got it?
Question, when she indicates then that the conversation did not occur and that the timing was such that none of what the defendant described could have occurred, you are saying that basically you have rejected the critical points at which their statements conflict. You have rejected her version.
Yeah, it would seem to me. She further testified, as I recall, that the walls were paper thin in that apartment and that she could hear conversations carried on in a normal voice at the door.
She did not testify that the conversation did not occur. She testified that she did not hear any.
Oh, exactly. But she testified also that she would have heard it had it occurred in that place at that time. I think it's enough contradiction here to allow her to ask the question.
That's fine.
Okay.
I didn't object to that. Her statement said that Lynn Marta said the conversation did not occur as part
Well,
of
in effect, that's what she said. What the credibility of that is a different issue that you can address in argument or with any other witness you wish to call. The point is, she did testify that had a conversation in normal tones occurred at that door because of her proximity, because she was walking to tell her that she may have disposed of Ms. Schaeffer's newspaper that she walked in tandem and was right at her door when she heard the shot, and that she actually heard what appears to be the last footfall, which preceded the shot by a second or a split second, which was her testimony now. At the preliminary hearing, she said it might have been a second and a half. At any rate, it was, that's the sense in which I take the question. Ms. Marta at no time said that she was standing there and that she saw the interaction and no conversation occurred. Okay. Go ahead, you may answer.
I don't want to suggest that I reject her testimony because that may imply something other than what I think I've done. What I did was to try to resolve the contradiction and consider what the possibilities are for resolving it, and the manner in which I thought the evidence that I knew best resolved it was a particular way. Yet I'm well aware that an additional thing would be very valuable, which is to determine how well one can hear from inside her apartment. I don't have any knowledge of that. The way in which I resolved this discrepancy to try to make as much sense as I could out of this and other things that conflict was to recognize that Mr. Bardo, despite having obvious motives to misrepresent what took place there, was also someone for whom, if it was true that he had this conversation with her, was likely to be able to give me an extremely detailed accounting of it, as he had with her jewelry and appearance and other aspects, because for him this was such a critical moment of life and so important. Whereas psychological research on eyewitness recollection has suggested, and I think responsibly so, that one of the sorts of things that is difficult for people to accurately recall is events preceding the dramatic or traumatic event that they're asked to recall. That is, while I would expect her to have vivid recall of the shot and her response to it, I think asking her what preceded that is.
So now they're arguing about whether the lady in the next apartment is remembering it correctly. Can we please move on? I think we've heard from this guy long enough. It's ridiculous. It really is ridiculous.
Asking someone to pay particular attention and recall for later reporting events that, when they occurred, were not particularly salient. That is, they become salient only in retrospect.
So based on all of that, you did in fact conclude that you believe the defendant's version when he said that there was a conversation. That was the bottom line.
I believe him that he had the conversation for multiple reasons, including that.
All I'm saying is that for all of the reasons you've stated, Doctor, you ultimately concluded you believed him.
Yes, that's right.
All right. Now let me.
People who do this sort of thing that the defendant does, do they have any tendency to try to blame the person in the sense that they brought it upon themselves by their own actions?
No more than anyone else, Your Honor.
Well, do people in general have that?
Yes.
The defendant, I take it, expressed extreme grief after on several occasions after the killing, did he not?
Yes, he did.
Would there be a natural tendency to try to attribute the killing to actions of the victim?
In the same way any of us would,
Right.
to rationalize it.
Is it possible that the defendant wanting to make himself accepted by the media, whatever his motive might be, that the defendant might have wanted to put more of the blame on her by having her be rude to him at the second visit than actually occurred?
If he'd done that.
I don't know if it's 3. I think it's 2 now. Anyway, 2 days, I think. Anyway, so the judge asked him, wouldn't he blame the victim because of like blame it that it was her fault. She got shot because of her behavior. In other words, that Bardo would blame Rebecca and say, well, it's her fault. I had to shoot her because she was mean to me. And then Dietz said, well, no more than any regular person would. No. If I did something bad to someone, I wouldn't say, oh, I had to do that. I feel bad because I had to do that to that person. That was a stupid answer. If I did something bad to someone, I wouldn't blame it on the person I did it to. That's ridiculous. I mean, unless they did something bad to me first, but not something like that. That's out of proportion. Shooting somebody because they were mean to you, I would not blame that on the person that I shot unless I was crazy. Which I wouldn't shoot somebody for being mean to me. But you know what I mean? Like, and again, I'm not making myself clear because I don't know how to express myself well. But I think you understand where I'm getting at. That was a stupid answer. This guy's stupid. I don't like him. I don't like him. I want you off the stand.
Then I would accept that.
Well, how do you know whether he did it or not? You have here the testimony of a lady who says very clearly that she puts forth events that if they occurred and she's reporting them accurately, there was no conversation whatsoever.
The way, what I meant in saying, had he done that,
Yes.
was had he sought to blame her. He was very clear with me. I think he was clear earlier as well that he's the one who shot her, that he was responsible. Now, to the extent that what he did could be seen as blaming her, the reason he would do that is really not to justify himself in the eyes of others so much as to be able to live with himself. Mm-hmm. Because to him, the whole issue was, is she wonderful and good, as he sometimes thought, or was she horrible and bad, as he sometimes thought? And if she was bad, then what he's done was justified to him. If she was good, then he's done something terrible and made a bad mistake. And he expressed his concern to me of having acted on the wrong assumption, that he didn't give her the benefit of the doubt.
Could that also be that he felt rejected by her in the first visit because she told him that she didn't want him coming to her door, went back and killed her deliberately, and then sought to justify in his own mind the shooting?
By reconstructing the entire story that he told me.
And that he may have told other people.
It's possible.
Well, you stated that psychological research has shown that people who are subjected to traumatic events tend to distort time. You said that on direct examination, I believe.
Yes, sir.
Oh, yes, Peter.
Doesn't the overwhelming majority of psychological research...
You can poop up. Because when I was at Epcot Sunday, we were in line for Guardians of the Galaxy, and somebody told me, one of the people I was in line with, told me that, oh no, oh, not another fire. Anyway, somebody told me that someone had pooped because the queue line has a wall on one side. Someone had actually pooped. It was up the wall. I don't know if they had diarrhea and bent over and then pooped up the. Who does that at Disney? That's disgusting, I guess. But see, that roller coaster is amazing, y'all. It always has an 80 to 90 minute line. So I guess the guy had to go, or girl, whoever had to go to the bathroom, didn't want to get out of line. That's disgusting. Okay.
Show that the distortion is in the direction of dilation of time rather than contraction?
Yes, it does.
All right. For the Ms. Marta to have distorted time because of the traumatic event, she would have to have contracted it, wouldn't she? In order to make the conversation impossible.
Well, both may occur, both contraction and dilation.
All right.
But the dilation is more common.
Far more common, isn't it?
Yes.
As a matter of fact, most psychological papers don't pay much attention to any contraction that might occur, do they?
That's correct.
They all talk about dilation of time, a lengthening of time, right? Isn't the usual explanation that is given for that the fact that when a person is shocked, as the athletes say, the adrenaline starts pumping, and that gives you your mind works faster and your subjective perception of time becomes elongated because more things are thought of and there are more mental events in that interval. Is that correct?
It's often described in that way.
All right. Can you give me any reason why in this case it should have contracted instead of dilated?
No.
All right. Did you examine the physical evidence in this case in order to make a determination as to which of the two versions was the more credible? The one by Lynn Marta or the one by the defendant?
I did not go to the scene.
No, but I'm talking about papers referring to physical evidence and things of that nature. Did you do anything like that?
I did some things like that. I don't know if I've done everything that might have existed. I haven't seen police reports that did any measurements of wall thickness or transmission of noise.
All right. What about the autopsy report? Did you examine that?
Yes.
All right. You examined that. Did you note, or has anyone told you about the testimony of Dr. Susan Seltzer to the effect that the bullet wound entered at an angle of 75 degrees to the horizontal?
I knew that there was an issue of the bullet entering at an angle, but that wasn't my recollection of the angle.
Well, that's what she testified to here, 75 degrees to the horizontal.
She didn't testify at the preliminary hearing.
Yes. Now, as I recall, her testimony was that the bullet hit a rib and then was deflected and went through the body at a different angle, approximately 30 degrees, as I recall. And I would say that with that short a path, that 75 can't be said with a great deal of confidence, but at least there's an indication of an extreme angle of entry. Were you aware of that at all?
I was not aware of what I take 75 degrees to the horizontal to mean.
75 degrees mean if someone is shot on the top of the head as they are standing upright, I would take that to mean 90 degrees to the horizontal. If they are shot parallel to the ground, 0 degrees, and 75 would be 15 degrees from being shot at an angle that would go through the top of the head if they were standing erect.
I had understood it to be the complement that is 15 degrees from the horizontal. So my understanding was incorrect.
And at any rate, the trajectory of the bullet as it entered the body was at an acute angle. A very high acute angle.
Yes.
Is that correct? If that is true, doesn't it cast a great deal of doubt on the defendant's version to you that she just stood back and looked at him when he pulled the gun? when he fired?
Coupled with his statement that he thrust the gun forward, and as he showed me that, it did not look like the angle would have deviated much from the horizontal. Yes.
And this is an extreme deviation from the horizontal, is it not?
Yes, that would be.
All right. Were you aware of any testimony that the victim in this case was a modest young lady?
No.
There was testimony in this case to that effect from several people. Given that she comes to the door with only a bathrobe and nothing else on, do you find it unusual that her feet are found outside the front door when answering the door to a stranger?
Yes,
That's very unusual, isn't it?
I think so.
Most women, even some that aren't very modest, wouldn't just step out to greet someone whom they've only seen once before, and that being a half hour to an hour before.
I would hope not, but I'm afraid they sometimes do.
If you put together, now you're a forensic psychiatrist, and that's a different practice than a purely clinical psychiatrist, isn't that correct? Don't you approach the defendant differently when you examine him than you would a patient?
Yes.
As a matter of fact, in the first interview, most psychiatrists and psychologists, give or take a few people from odd schools, don't they usually try to avoid confrontation at the first interview?
Yes.
Just let the defendant talk. But if you're a forensic psychiatrist and you're going to see somebody only a limited amount of time, you might have to do any confrontation that you will undertake the only time you get to see him, or maybe the second time you get to see him. Isn't that correct?
It's true that you may have to do it sooner than a clinician treating a patient would.
In fact, some clinicians never confront them. They figure if the patient is lying, it'll come out sooner or later.
Or that it doesn't matter.
Yes.
Yes, sir.
But with a forensic patient, so to speak, you have to get to the truth immediately. And not only that, isn't it true that truth and falsity as to events is far, far more important in the forensic arena than it is in the clinical arena?
Yes.
Sometimes in the clinical arena, it's just important that the defendant believe what he says. The objective metaphysical truth, so to speak, is irrelevant, isn't it?
In treatment, that's right.
Yes. All right. So you made no attempt to call Dr. Stolberg to find out the answer to this very critical issue of whether or not the defendant had thought about killing Rebecca Schaeffer on the second visit. Is that correct?
It's correct. I did not call him.
Is there a reason for that?
Yes.
What is it?
I understood from Mr. Galindo that Dr. Stolberg might be testifying, and we wanted to keep our evaluations, or at least I wanted to keep mine independent of his, if he was also going to testify, so that there wouldn't be any contamination.
Well, do you think that merely asking Dr. Stolberg a question regarding what the defendant said to him would contaminate your opinion?
Any contact with him would have allowed the cross-examiner to suggest that we had colluded in some way, and I wanted to avoid any appearance of that.
Isn't it more important to get the facts than it is to avoid the appearance of collusion?
It's important to get to the truth.
The defendant has given a number of statements having to do with all kinds of events, and you knew that he had lied about several of them. Weren't you concerned that he was lying to you about this very critical issue of what his intention was when he went there the second time?
Yes.
All right. And
I feel like now that the judge is just chastising him for being a bad forensic psychologist. He's just messing with him now.
if Dr. Stolberg had been a lay witness whom you had heard had said this, you wouldn't have any hesitancy whatsoever in contacting Dr. Stolberg as a lay witness.
Or of arranging in some manner to get the answer to the question from him.
All right. And wasn't there a means available to you to get the answer from Dr. Stolberg without actually contacting Dr. Stolberg and creating this impression that you were afraid of collusion between the two psychiatrists?
Well, now that you mention it, there is. I could have written him a very specific question.
You could have asked Mr. Galindo to have his investigator go and talk to him and ask him that specific question. Let me ask you a question. Let's assume that the defendant on the second visit, this is just an assumption, hypothetical question, went to the apartment with the intent to kill. He went to the apartment with the intent to hide so that she would come to the door, knowing that she'd come once for him and inferentially had come once before that morning for the person who was delivering a script, because he asked that person whether he had delivered a script to her. But he went there for the purpose of killing and rang the buzzer and then hid. She comes out wondering who it is, sees no one at the door, expecting the possibility of a script being laid or something else being laid, or somebody having walked away because the defendant said that he rang 3 times before she came, and she comes out, opens the door, leans around to see if anyone is there. He then shoots her. Wouldn't that account simultaneously for the angle of entry and for the fact that her feet were outside the door?
It certainly accounts for the entry wound. It would account for her feet being outside the door. I don't see how she would fall inside if he were hiding to the left of the door as one approaches it.
Hiding to the left, as she comes out, he steps out and shoots her. And the force of the very powerful ammunition he has throws the upper body backwards. In fact, she may even have come out further than the feet indicate, because the feet may have been thrown backwards as well. Is there anything illogical or inconsistent about the scenario that I have just described?
Nothing that I'm aware of, Your Honor.
All right, proceed.
And also consistent with that scenario, Doctor, would be the witness, Lynn Marta, not having heard any conversation at all, correct?
That's right.
You did not go to her apartment to check out the acoustics and see if indeed she could hear a pin drop from the inside of her apartment, did you?
No.
You did not even take time to interview her personally, did you?
No.
You did not talk to any of the police officers who interviewed her personally, did you?
No.
Or talk to any of the police officers who may indeed have sat inside her apartment to observe whether or not the acoustics were as she described them, did you?
No.
Nevertheless, you rejected her testimony in favor of the defendants, whom you concede has a clear motive to lie.
Well, I explained how I went about determining best how to reconcile that discrepancy, but I don't care to characterize it as rejecting her testimony.
You chose the defendant's version then.
I think I understood a way that his made sense to me, and understood a way that she might have misrecollected.
But may not have.
That's right.
All right. So if Lynn Marta's testimony is correct and there was no conversation and Rebecca Schaeffer was indeed shot virtually as soon as she opened the door and probably bent over to look for the script, having already stepped out on the porch, then wouldn't you agree that the defendant would have been lying to you?
If
Lynn Marta is correct.
about the time,
And no conversation. Would you agree that the defendant had lied to you?
Certainly.
And if that were the case, that Rebecca Schaeffer was indeed shot without any preceding interaction with the defendant, as soon as she stepped outside, would that change your opinion any, doctor, as to whether he'd gone back for the express purpose of killing her and laid in wait for her until she opened the door?
Again, assuming he hides out of sight until she opens the door and then shoots her as soon as she's in clear view.
Even if he doesn't hide, he goes back for the express purpose of killing her, rings the doorbell to lure her out so that she will step outside in an unguarded moment so he can have a clear shot at her. Would that change your opinion any as to whether he had lain in wait or perhaps easier, premeditated the murder?
Yes, it would.
You would agree then that he had?
That's correct.
Now, doctor, there was a list that was recovered that was dated November 19th, and it says Thursday on it, and there's been a stipulation that November 19th fell on a Thursday in 1987. Even without that, and I believe there was also judicial notice taken of that, but even without that, based on what the defendant told you, would you agree that the list I'm referring to actually refers to a trip taken in July of 1987 when the defendant went to Burbank Studios armed with a knife?
No, I think it was a plan to go in November of 1980.
It stopped in mid-sentence. That was weird.
He went in July of 1987, and he talked to you about the list he made.
He told me where he got the concept, I don't lose, period. I don't remember if he was speaking about that in the context of that list or not.
Okay. Do you recall seeing that list?
Yes.
All right. That list said knife, book, bags. Would you agree the book he might have been referring to even in 1987 was Catcher in the Rye?
I think so, yes.
All right. Would you agree then, sir, also that that list would seem to look very similar to the list that he compiled later in 1989?
Yes, it is.
On the fourth trip now, we're talking about July of 1989. We again have this evidence. Would you agree that it constitutes evidence of pre-planning in the list that says things for gun, scratch-off serial number, bullets, Catcher in the Rye, Joshua Tree? Would you agree?
That it what?
That list constitutes evidence of pre-planning for a murder?
Yes.
And in this fourth trip also, on June 30th, he delivers a letter to his sister Arlene that would appear to contain a statement of intent to kill. Would you agree?
The date you gave in there was what?
June 30th. That's when he gave it to his sister.
Oh, yes.
And then we have a statement to his niece Merrick. The statement, I think, was, I'm going to put Rebecca to sleep. Do you recall that statement?
I recall a statement to the effect of put that girl to sleep.
And then he showed a picture of Rebecca to his niece Merrick, correct?
Yes.
Do you detect any ambivalence in that statement to his niece?
Only one side of it, but not ambivalence per se, no.
That's just a statement of intent to kill, is it not?
I think so.
All right. And do you detect any evidence of ambivalence in the list showing gun, scratch-out serial number, bullets, Catcher in the Rye, etc.?
I'd like to look at the list again.
Sure.
I don't have it in front of me.
I have the original here. No, I don't. Here it is. Thank you.
Perhaps the presence of the Joshua Tree lyrics and Rebecca's photo and address, but those could also have another meaning besides his adoration for her.
He did indicate to you, in fact, that was a CD that he listened to when he was feeling animosity for her, didn't he?
Among other things.
Yes. In context, finding that tape listed on the list that we do, may we infer then in this case, in the context in which we find it, that it was because it inspired animosity in him that it was on this list?
I don't think so. He described conflicting emotions even with respect to U2 and the Joshua Tree album. He talked about the hands that love being Rebecca. He talked about his love and adoration for her.
Yep.
And also his animosity.
Pistol weighing heavy. Talked about that too, didn't he?
The mission, that's right.
All right. Now, what I'm asking you is when you find that CD on the list that is in front of you, the list that includes gun and bullets and Catcher in the Rye, money and map of LA, can you tell me, Doctor, based on the entirety of that list, whether you detect any ambivalence in it?
If all I had with the list, I'd say that this is a list of someone preparing to make a hit.
All right. Now, wouldn't you agree, Doctor, that with respect to this trip, the preparations were very elaborate?
Very elaborate?
Yes, very elaborate. He purchased a gun. He wrote the letter to his sister. He made the statement to Merrick. He compiled a list of things to do. He hired a private detective. Wouldn't you agree that those are fairly elaborate preparations?
For Robert Bardo, that was probably the most elaborately prepared event of his life, yes.
And this particular occasion, unlike the previous ones, he took very definite steps to make sure that he would indeed find Rebecca Schaeffer, did he not? He hired the private detective.
Correct.
Now, the letter to his sister Arlene, you mentioned in your testimony, you theorized, at least I understood, that the defendant did have another reason for wanting to kill Rebecca Schaeffer, and that was to rid himself of an obsession with a remote and unobtainable person. But you said that you did not believe that motivation was consciously held, correct?
I don't think that was foremost in his consciousness. I don't think it was a conscious motive at the moment he killed her.
Let me read back your statement so that we have a common ground to take off from. Do you have the transcripts?
I have some of them.
All right, let me share mine with you. This is page 218. There was a level at which he wanted to be stopped from this extreme focus on another person who is so remote, and that there is some level at least which is killing Rebecca Schaeffer is in part an effort to stop this process, though I don't think it was the predominant or conscious motive. Okay? All right, so we're agreed that that was your statement at the time.
Right.
Okay. Now, you reviewed the letter that he wrote to his sister Arlene, have you not?
Yes.
Do you have a copy of it at hand? I'll share the original with you. I'm going to read just a couple of excerpts from it. What I do is going to cause you to have a lot of negative feelings about me, and you won't understand it all. One day you'll know what I have done. I believe my mission is my destiny. I must reduce myself to one again. What I'm about to do is something you expected Jeff to do because you know how he is. The thing is that I have hidden it now it will surface. Don't hate me or stop me from doing what I have to do. By the time you read this, I'll have already done it. Just remember the brother you can remember and not the one you may hate me for. Doctor, from reading these lines, do you get the impression that he intends to do something very negative?
Yes.
In fact, when you read the entire letter, do you also get the impression that he intends to kill?
Yes.
And have you read the other letter that he did not send to Arlene?
Yes.
Oh, I'm sorry. The letter I just read from is the letter he did not send to Arlene. This is the letter that was kept in the attic. You read that. You didn't know it was from the attic at the time.
I only knew there were two, and I read them both.
All right. Now, the one that he did not send at the end says Rebecca S., 1967 to 1989.
Right.
All right. And that, among other things, gives you the distinct impression that what he intends to do by the mission, what he means, is to kill Rebecca Schaeffer, correct?
Yes.
Now, the letter that he actually did give to his sister which was People's 30. I suffer from fixations with the unattainable. Now I'm going to fix that. You read this and maybe you think I'm just a confused person, but I'm going to solve that this summer or fall. I'm obsessed with something, underline, I can't have. So I'm going to make it so that something, underline, doesn't exist anymore. Please don't tell anyone about this because Mom and Dad will give you a call and tell you what I have done. If you tell anyone, I'll deny it. You read this letter, Doctor?
Yes.
Would it not appear then that the motive you thought he held unconsciously was rather consciously stated in this letter?
The motive to rid himself of the obsession that I said was not conscious at the moment he pulled the trigger is expressed consciously there, just as he expressed it consciously to me.
I'm sorry, I did not understand your testimony to be so qualified. But in any event then, what you are saying now is that at times he consciously held that motive and at others he did not.
That's right.
On what basis do you have, or what independent corroborating evidence do you have to indicate that he did not consciously hold that motive when he went to see Rebecca Schaeffer the second time?
The only basis I have for when that was conscious or not is his own statements regarding his consciousness in writing or what he has said. There is no kind of independent corroboration available of anyone's consciousness.
But there might be physical evidence or the statements of witnesses that would either tend to support or refute that, correct?
Nothing other than the symbolic productions of the human whose consciousness is at issue.
No, we can be probably more down to earth than that, can't we, Doctor? In this particular case, although the defendant told you he had a conversation with Rebecca Schaeffer at the second visit, we do have a witness who says that no conversation, in essence, what her testimony conveys, is that no conversation occurred. Isn't that correct?
Right, which says nothing about his consciousness.
But it may say something about his intent, might it not? If indeed it occurred as the witness described, in other words, Rebecca Schaeffer was shot immediately upon opening the door, that tends to give us some circumstantial evidence of what the defendant's state of mind was at that time, does it not?
Tells you a great deal about his behavior.
And from that, we may infer what his state of mind was, may we not?
To some extent, yes.
This letter, Doctor, that he gave to Arlene that I've marked as People's 30, is a fairly clear statement of intent to kill. Wouldn't you agree?
Yes.
And on the end of the letter where it has the grave marker, it says hint 1967 to 1989. That leaves you with no doubt what he intends by writing this letter either, does it, Doctor?
That's right.
And in this letter, there is no mention of his great love and confusion, is there?
Not in those words.
In this letter, what we have is a statement by Robert Bardo saying he plans to kill something he cannot attain, roughly. I mean, that's the import of that letter, is it not?
Yes, that's right.
And in it, then, he gives a reason for killing Rebecca Schaeffer, does he not?
Yes.
And someone who gives a reason for killing is someone who premeditates and plans to kill and kills deliberately, do they not?
Not necessarily.
But it may indeed import that, may it not?
Certainly.
When someone says, I went to kill her for the following reason, does that not indicate to you that some consideration and thought was given and the action was taken upon their conclusion of that consideration?
It indicates that there was a time when the consideration happened.
Now, you indicated that you felt the defendant's characterization of the first visit was accurate because he expressed joy that you felt he could not have feigned, correct?
I thought it unlikely that he had. I don't know if it would be impossible. I don't think that would be impossible.
Okay. Let's assume for a minute.
3 o'clock. You want to stop now or continue for a short period of time, or what?
I think I have, we can stop now. I have about 10 more minutes.
We could take 10 minutes now. We have a fresh reporter, so we don't have to take a break now. So why don't you go ahead?
Doesn't matter. What does the court prefer?
Go.
Go. Let's assume for a moment that he did not feign the joy. A person can feel joy for many different reasons, might they not?
Yes.
And in this particular case, as you know, the defendant had been to Los Angeles to find Rebecca Schaeffer 3 times previously, correct?
Yes.
And he called on the phone trying to reach her as well numerous times, correct?
That's right.
Then might that joy you saw have had its cause in the feelings of victory, that he had won, he had located his target? Might that not now also account for the expression of joy that you saw?
I think he felt he had won in locating this woman whom he targeted, but I don't think he took joy in her death, no. You say might, I suppose that's possible, but I see no reason to think he would take joy in her death.
Well, I'm really not asking that. All I'm asking is when he expressed joy to you in discussing the first visit, that joy is not necessarily joy born of great affection or love. It may, in fact, be joy born of success or victory, achievement. In that sense, it was not feigned. That is what I am suggesting. Did you consider that possibility?
It's possible.
And when the defendant said to you that he felt, why kill her when I can talk to her whenever I want? Did it occur to you also that he might have felt that now he'd found her, he could also kill her whenever he wanted?
That's possible too.
And so when he gives the expression of joy and he is reliving the joy of having succeeded in finally finding her, he is also expressing the joy at knowing he has now the power to choose when he will ultimately kill her. Isn't that also a possibility?
It is.
Did you ask him, doctor, whether he felt or thought, after having found her the first time, that now the power was in his hands to choose when he would kill her and by what means?
I did not ask him about that, no.
Now, I wanted to point out something else. You indicated that by virtue of a defendant's very detailed statement to you, that may be one method in which to measure his veracity, correct?
I don't recall what I may have said about it.
I believe it was in response to some of the court's questioning just a few minutes ago. You indicated that one of the reasons that you believed the defendant's statement concerning the conversation was the detailed nature of the recounting that he gave you of that conversation. Do you recall that?
No, I don't, but
Do you agree with that?
I agree that that he gave me a detailed accounting of the conversation, and that I did believe him about the conversation and about the details. The mere fact that he gave a lot of detail doesn't carry much weight with me as to whether the statement's true.
then the fact that he was able to give you what you consider to be a detailed recounting of that second conversation did not assist you in determining whether or not the probabilities favored his veracity over Lynn Marta's.
The particular details he gave me did. I do now remember what you're alluding to. That is, he recollected a great deal from what he'd seen visually from both visits, which I thought was confirmation of the importance he placed on this meeting, and that his attentiveness at that point was high. And so, and I don't have any reason to doubt his attentiveness was high.
Certainly, I don't think any of us would doubt that. But with respect to the conversation that occurred the second time, is it your memory, Doctor, that he was detailed in his accounting of the nature of that conversation at the second visit?
At various times, he gave different details, and altogether, I think one would have to say that he recounted quite a few details.
Well, Doctor, if you compare his recounting of the second conversation with his account of the first conversation, did you not notice that his rendition of the statements made by himself and by Rebecca Schaeffer were considerably fuzzier on the second visit than they were on the first one?
Yes, I think that's true.
And might that considerable fuzziness be due to the fact that he was fabricating that conversation?
That's one possibility.
And what is the other possibility?
That it was an extraordinarily traumatic event for him too.
Do you think that perhaps the shooting of Rebecca Schaeffer was a traumatic event for him, Doctor?
I'm sure it was, yes.
Yet he recounted that in very consistent and graphic detail without any of that fuzziness, didn't he?
Well, there are differences from time to time in his accounts in it.
Yet he was very, as I recall the videotape, very concrete, very definite, and without hesitation in describing in graphic detail what occurred when he shot her and she died. Do you recall that?
I sure do.
And when you compare that very graphic and concrete detail concerning a very traumatic event like the shooting to the fuzziness of the recall concerning the statements made in the second conversation, do you not see a great disparity in detail?
I think there's a disparity between his efforts to recall what he said was mumbled while he's fumbling in a bag and getting upset, fearful, anxious, and then angry, between his capacity to remember the horror of seeing her response to the gunshot.
Well, he refers to some statements that are mumbled, but he also refers to some statements that are clear, doesn't he?
Some of each, that's right.
And when he refers to the statements that were clear, Doctor, he repeatedly says, I can't remember. Do you recall that on the videotape?
He says that, and then ultimately he's able to say enough to make plain what happened.
The general gist of what he wants to convey, yet not the detail of the conversation as he did in the first visit. Would you agree?
That may be so.
Then all of that taken together might in fact indicate that that conversation did not occur.
Well, maybe the conversation didn't occur. I've already acknowledged that, but I don't think this comparative fuzziness is much to hang any hat on.
You don't think that the comparative fuzziness and inability to recall detail in the second conversation at all indicates to you that he may be lying to you about having had a conversation the second time?
He may be lying, and there are some reasons to question that. I don't think this is one of the better ones.
And then what are the other ones that might cause you to doubt?
The ones we've already covered.
Concerning the contradiction in testimony?
Yes.
And yet, we know the outcome of that decision in your mind concerning who to believe.
Yes.
I take it then you also believe the defendant when he said that he attempted suicide after the murder when he put the gun to his head?
Well, I started by disbelieving it because I usually disbelieve that claim. I hear it fairly often, and I often think it's a lie.
diagnosis already.
and then came to think that he might have, that might be so. I don't particularly believe that he made what I would call a suicide attempt at that time, but he might have. It may be so.
In concluding that, doctor, did you take into account the fact that 3 witnesses testified to seeing him run virtually immediately upon the shot being fired?
The accountings I know about included people who had to turn around to look in response to the shot, and I took that into account.
Well, doctor, as I recall the testimony of Oscar Marino, he stated that he had crossed the street, he heard the shot, he stepped 1, 2, and looked. Maybe that's 3 seconds, by which time the defendant was already running on the sidewalk. Given that testimony, sir, do you think that the defendant was telling the truth when he described to you standing and watching Rebecca Schaeffer and putting the gun up to his head, and actually said he was fumbling with it a little bit and then putting it up to his head and watching her and then finally running?
Well, as I said, I don't know whether to believe him about that. I think it may have happened. I think it takes longer to say it than to do it, and that it can happen very quickly. To look, raise a gun, run.
Nevertheless, wouldn't you agree, doctor, that the events as he describes them, and the amount of time that would seem to have transpired by his description, does conflict with what the other witnesses testified to seeing in terms of how quickly he ran after the shot was fired?
To the extent that it makes me doubt whether that happened.
Okay. Now, you also testified that the defendant was uncertain about whether he really found Rebecca Schaeffer's apartment, and you believe that that's why he asked those people in the neighborhood, especially Irene Tishkoff, if she knew this girl, Rebecca Schaeffer. Do you recall?
So there were a couple reasons. That was among the ones I mentioned, and maybe others too.
And what was the other one?
Another one that I believe I mentioned was that he thought it was too good to be true. He couldn't believe he was really there. And another I think I mentioned was that he didn't think that looked like an apartment building, but that I think he resolved with the taxi driver.
Right away.
And there are others as well.
Okay. Okay, now, would you agree then that when the defendant told you that the primary reason he was asking this was to determine if he had found the right place?
Yes.
You are aware then, by the testimony, of course, that no one whom he asked about Rebecca Schaeffer responded by telling him where she lived.
That's right.
In fact, they didn't respond at all.
That's right.
Then how do you account for the fact that he told his sister Arlene that he was just a block away from her house, and after which he hung up and did in fact go to her apartment, if he did not know where she lived all that time?
There could be another person that I don't know about whom he did ask and who confirmed it, though that's pure speculation.
Very much so, because even the defendant never told you that.
Right.
All right.
He could have walked to the mailbox and seen the name, but not pushed the button, but I didn't ask him about that.
Nor did he volunteer it.
And
Correct?
Correct. And he may have by then decided that this was the place. I don't know.
Would you agree, sir, that when you look at the fact that he was apparently certain, even by his own statement, that he had found her apartment by the time he called his sister Arlene, and based also on the fact that we have no evidence that any witness told him where she lived, that he in fact lied to you when he said he was asking witnesses about Rebecca Schaeffer because he was uncertain that he was in the right place?
No, I don't think so. He knew he was at 120 Sweetser. I don't think he was certain that she lived there or at another address. He knew that that address had been put on her DMV notice in January of 1989, that's when they had the change of address. This was 7 months later. He didn't know if she was still there or not.
Then why did he tell his sister he was going to her apartment? And both his sister and the defendant say this. There's no dispute.
There's no dispute about his saying something to the effect that he's a block away. There is dispute as to the exact words. In one telling it was, I'm a block away from where she lives. And another telling it's, I'm a block from Rebecca's. And another telling I'm in LA and I'm nearby. There are linguistic differences. None of them go to the point of whether he's come there to kill her or whether he knows he's near her place and so on. But I don't think they convey certitude that she is there and she still lives at this place.
If they do not convey that, sir, then how do you account for the fact that for 2 hours prior to the phone call to Arlene, he was there in that neighborhood and did not go away somewhere to look and see if she was on Sunset Plaza or some other address?
He hoped and expected she was there. He went there to find her. There's no dispute about that. And he spent that time in the vicinity, and if what he told me is true, going to a diner in anticipation of going to her door.
Which would also indicate that he knew he was in the right neighborhood, would it not?
He knew he was in the neighborhood that address was. He expected she would be there or hoped she would, and yet it seemed too good to be true.
So in short, I suppose what you're saying is that when he said he was asking people about her because he was unsure if he was going to find her there, he was unsure if he had the right address, that you believed him.
I believe that that's what he thinks, and that he meant to be conveying to me the truth. I'm not sure that that's even what he thought then, and even if that was his conscious thought then, I don't know if that's the truth, in as much as it's equally plausible to me that he was hoping someone would tell him that she moved already, or that someone would call the police and he'd be arrested. There are many other possibilities.
None of which you have any evidence for, do you, doctor?
Only the fact that he hangs around outside for this amount of time instead of going to the door like a normal person and ringing the buzzer.
Well, first of all, doctor, as you've indicated to us before, a normal person would not have gone to her door under these conditions, would they?
They wouldn't have gone with the gun in the bag and the CD to give her and the letter that asks, have you gotten my other letters? No.
Oh my
Or with a plot to kill her and the letter written to his sister indicating a plot to kill her. All right.
That's right.
So we are not talking about a normal visit, are we?
That's right.
Are you
All right.
kidding me, Marty?
And you're aware, of course, that during all this time that he was hanging around the neighborhood, he never did ask anybody where Rebecca Schaeffer lived.
That's right.
Now, might there not be another plausible explanation for his accosting that neighbor, Irene Tishkoff? In light of his statement to Los Angeles police that he planned to wait for her and shoot her as she went in or out of her apartment, and in light of the fact that he never asked any witness where she lived, in light of that evidence, doctor, doesn't it seem more likely that he was attempting to find someone who knew her and could tell him her schedule so he would know when to expect her to come in or out of her apartment?
It could be a bumbling effort at an ambush. That's possible.
You also indicated, doctor, that the defendant said he panicked and ran, making people aware of his flight.
Yes.
All right. First of all, he did not drop the gun on the sidewalk after the murder, did he?
No.
And in fact, he put the gun back in the bag after he shot Rebecca Schaeffer, didn't he?
I think it was always in the bag.
How much longer?
You want to stop? Take a break? Let's take a break.
I'd like the answer.
10 minutes, but I said that 10 minutes ago, so I can't
No, you
rely
said
on
that
me.
20 minutes.
I did.
All right. Take a recess until 3:30.
Yes, this is the last part. We've got like half an hour left of this time.
And after the murder occurred, he put the gun in, you believe it already was in the bag, but whatever, he did carry it inside the bag, didn't he?
That's right.
And he did not drop all the evidence in a heap on the sidewalk, did he?
No.
As a matter of fact, when he ran down the alley, he distributed it piecemeal on different rooftops as he ran, did he not?
Some of it, that's right.
And that's right. And the gun with the bag and the postcard in it, he deposited in a dumpster, did he not?
The gun in the bag with some other things. I'm not sure which things were still in the bag when he deposited it in a dumpster.
And then even lied about where he had disposed of the gun later on when he was arrested. Isn't that correct?
Yes. Well, yes and no. He said he threw it in the alley, which was true, but it was a dumpster in the alley into which he threw it.
But he certainly deliberately misled the police about where he deposited that gun, did he not?
That's right.
And when he told you he got off the bus in Tucson, allegedly to commit suicide, didn't he also tell you that he thought the entire police station was going to be waiting for him at the bus station?
I don't recall that, though he did say that while still in LA, he expected to be shot down any moment, and that he continued to think the police would get him and would know who he was.
You don't recall the statement he made to you in that videotape in which he said while he was on the bus, he was thinking that when it got to the bus station, the police would be there waiting for him?
I didn't notice that he said particularly that.
As a matter of fact, though, if you recall Officer Norton's testimony, when he saw the defendant walking up and down the off-ramp, when a car actually did come down the off-ramp, the defendant walked off to the side and out of the way, did he not?
I haven't seen that testimony.
In his letter to his sister Arlene, he indicated that he was not suicidal, didn't he?
Yes.
Now, Doctor, if the defendant lied to you about what his plans were for Rebecca Schaeffer when he left for Tucson, would that change your conclusion as to whether he did lay in wait to kill Rebecca Schaeffer?
Well, I haven't been asked to express a conclusion on that.
I'm just asking a hypothetical. If. I'm not asking you to express your opinion about whether he lied to you or not at this moment.
If he lied to me about why he went?
Yes, if he lied to you, remember we discussed the discrepancy between the statement to Los Angeles police and the statement to you. If he was lying to you about having a dual purpose, or at least having the idea in mind that they would interact when he got here, if you discovered that you got the wrong impression from that, or that he deliberately misled you about that, would that cause you to change your conclusion as to whether or not he lay in wait for her when he went back a second time?
That would depend on why I was wrong. As I think I've said before, it's not his statements to me about a dual purpose for the trip that I'm relying on there. He never said other than that he was going to go kill her when he left. And also, he loved and adored her.
And that's what led you to conclude that he was uncertain about what he would do.
That's what led me to conclude that he is an ambivalent man capable of splitting, capable of responding in two different ways, absolutely polar opposites toward the same object.
And you say this in spite of the fact that you have acknowledged that there is physical evidence that would tend to indicate there was no ambivalence in his plan to kill Rebecca Schaeffer. I'm speaking of the letter to his sister and the list.
Well, that's not exactly right. I mean, it's right that those things that you called to my attention before the break show his intent to harm her. And it's true he had the intent to harm her. But it's also true that those things in part add support to the other side of his dual affect emotion toward her, in that they simultaneously, in differing ways, show that he had this continuing obsession with her and that she was very special and important to him. and even indirectly that his emotions toward her included that positive side.
Well, doctor, tell me what is the positive. First of all, you say he had that these pieces of evidence I've referred you to indicated intent to harm her. Doctor, at the end of the letter to his sister Arlene, he puts a grade marker, year of 1989. That sounds like kill, doesn't it? Not just harm.
Exactly.
All right. So when you say harm, you mean kill her. That's what is shown in this letter, is it not?
There's no dispute about this.
All right. And in this letter, he does speak of her as an obsession, but as an
They changed the day. It's tomorrow. But last night, and the judge said, at the verdict, he said Wednesday. And then last night, when I found it, it said today. And then when I went to do it, it said tomorrow. So they changed the date. So we're doing that tomorrow.
unwanted obsession, one that he wants to get rid of, correct?
Among other things.
Among what other things, doctor? He doesn't say here he
Well-
wants to adore her.
No, he doesn't, but he shows that he does.
By the fact that he is obsessed?
Well, I'd like to look at the letter and I'll show you exactly what I'm referring to. He says he's going on an odyssey to face his destiny. He says he has trouble with reality, that he's emotionally disturbed, which still troubles him, that there are two Robert Bardos. One part of me, he writes, is sweet, nice, compassionate, helpful. One part of me is very dark, tormented, very evil. I'm also a part where someone is a part of me. He feels a linkage with Rebecca Schaeffer, is my interpretation of that passage. That she is a part of him or he is a part of her. He's not sure which way to put it. So he gives the alternatives. And that his mission's to reduce that number to 1. He's going to kill her in order that he not be two people anymore. That he be one person. This is a classic example of the phenomenon of splitting. He sees in himself the good side and the bad side. I've just read you what he said about that in this letter. If he goes to Los Angeles, he can get rid of the bad side if he can put it entirely on her and destroy it. Then there'll only be one of him, and that would be the good one who's left over.
Actually, doctor, isn't it true that, oh, I'm sorry, I thought you completed.
But of course, at other times, she's the good side and he's the bad side. There's no...
Okay. I am not a psychiatrist, obviously. But when I was in nursing school and I did my psych rotation, we learned that splitting was something else. It is not what he's talking about. I'm not saying he's wrong. I'm just saying this was, when was this? The early 90s? And I went to RN school in the early 2000s. So we're talking like a 10-year difference. It could have changed. Because I feel like psychiatry is the medical thing that probably changes the most. But what I learned splitting is like, let's say you're a patient in a hospital and on one shift you have a nurse or a doctor that you don't like, and then you want to maybe, I don't know, like your next, the nurse that comes on the next shift or doctor or whatever, you want to get sympathy from that healthcare giver. So then you would say to them, that nurse I had this morning, boy, she was a bitch. She didn't do anything I asked her to do. She treated me like trash, but you're nice. I like you. I hope you're my nurse every day from now on. That's splitting. When you try to get sympathy, you badmouth one person to get sympathy from the other person. That's what splitting is. But like I said, it could have changed. It could be splitting is two different things. So, yeah, DID is completely different. But they used to think that schizophrenia was DID. They've changed that too. Schizophrenia is hearing voices. But they used to think that, I mean, that's just part of schizophrenia, basically. But they used to think that schizophrenia was split personality. But now it's dissociative identity disorder. So yeah, so things change all the time. So, but he's saying splitting like there's a bad side of him and a good side of him, but I didn't learn that. I don't think that's kind of true of everybody. We all have the capacity to do bad or do good. I think that's true of everybody. I don't think that's a mental disorder.
Way for me to tell you this rationally as a rational thought, because it's not rational. But what he does with her is to split her so that at times she is all good, an angel, wonderful and perfect to be adored. And at a moment's notice, like the flip of a switch, she can be all bad, all evil, the worst. Those are two ways she can be. It is a classic defense mechanism. It is known as splitting. It occurs in multiple conditions, and it's uniformly understood as something that can change in a flash. To regard that object as all good versus all bad.
Does that require a stimulus or a triggering event to cause the change over from one to the other?
It doesn't, though usually or often one can perceive one.
All the instances of what you've called splitting in this case have occurred as a result of some kind of stimulus.
Yes, but the stimulus may be an internal event of thought.
Well, do you know of any instance in this case where the splitting was not caused by some act or perception of Rebecca Schaeffer?
Well, he's done splitting with other people, like Mrs. Morris.
Doctor, I'm asking you about Rebecca Schaeffer. Do you know of any instance, for example,
Sure.
he, number one, when he saw her in the scene where this gentleman, Sharkey, went into a bed with her, would that be an example of him splitting at that point?
Of his exercising splitting, if he was seeing her favorably before that event and then saw her negatively at that moment, that would be an example of splitting.
Isn't that what you testified to? At least I understood your testimony to be that they started getting negative feelings about her when she appeared in that movie, in that scene.
Well, and at other times, Your Honor.
Well,
I don't know which position he was in when he went to the movie that night.
Oh, I see.
Because
He may have gone to the movie already in a negative position toward her.
Could be, I don't know.
So that may not be splitting. We
Well-
can say definitely under your version of the events on the second visit that there was splitting at that point.
If he, I think there's splitting toward her if he killed her because she's arrogant and at any other time loved her because she was perfect and switched back and forth. What the version of events that he told me supports is the idea that he made that transition during the second visit.
When you refer to splitting, are you talking about a pre-existing condition where the person is split in their feelings towards someone, or are you talking about the transition from one of the feelings to the other?
Neither.
Okay, what are you talking about?
Splitting is a defense mechanism like the defense mechanism of repression or denial. It is one that is characteristic of particular patterns of development. It's referred to by psychoanalysts as a narcissistic defense, and by many people as a primitive defense mechanism. And that mechanism has to do with the individuals attributing to some external thing, usually a person, that's called an object by these theorists, but that external object is imbued with all good qualities or all negative qualities. The splitting is to see people as all good or all bad, as opposed to seeing them more realistically as a mixture of good and bad traits, which is the more mature view of other people.
All right, so the splitting is the structuring of the attitude toward the person that is part of the patient's personality. Is that correct? At the point that they have split. It's not the transition from a feeling of love to a feeling of hate.
It is not the transition.
Okay, the transition comes about because of the splitting, because the splitting is there
That's
already.
right.
I see. Okay, go ahead. Continue.
In the letter to Arlene, can you show me where he speaks of Rebecca Schaeffer as being an angel or a devil or good or bad?
I don't think that language is in this letter.
In fact, he doesn't speak of the attributes or lack thereof of his target or his obsession at all, does he?
Only that she's unattainable to him.
So what he is talking about in that letter is that he wants to kill her in order to eliminate the pain of not getting what he now realizes he cannot have, in essence. I'm not attempting to quote him, I'm interpreting it. Would you say that's a fair interpretation?
That's his overt statement.
All right.
But I think psychiatrists might reliably agree, which is not often the case, that is, repeatedly agree on reading this to say it also shows his desire to rid himself of the bad part of himself, which he's projected onto her.
Which may also mean that the bad part of himself is that part which has become obsessed. Correct? And he seeks to eliminate that bad part by eliminating the object of his obsession. Might that not be a fair interpretation then?
Yes, that's the way to put it.
All right. In that case, doctor, when he says that he's having problem with reality, might he also be telling us then in so many words that the problem he's having is that in reality he can't have her?
I was not incorrect.
That's one of the problems he's having. That's not the problem with reality. Well, there's a sense in which it is. I mean, an even broader sense than you mean. It doesn't just mean I have a practical problem, I can't get her. His problem is that his fantasy life is completely wrapped up with her. And occasionally reality impinges on that.
And he realizes that his fantasy life is unrealistic and unobtainable.
Yes.
All right. Let me ask you this, doctor. If the defendant lied to you about why he loaded up the gun when he first got to her neighborhood, would that change your conclusion about whether he lay in wait for her at the second visit?
It might, depending on what he said about it.
If the defendant lied to you about why he filled the empty chamber between the first and second visit, would that change your conclusion as to whether he lay in wait for her the second time?
That might too, depending on why and what happened in the intervening period.
Well, Doctor, with respect to the why of loading up the gun when he first got to her neighborhood, he told you it was to shoot through security. Do you recall that?
Yes, I do.
And he told the police that it was for self-protection.
That's right.
Okay. If you found out that the version he gave to you was a lie, and that the truth was he brought the gun for the purpose of killing Rebecca Schaeffer, would that cause you to change your conclusion about whether he lay in wait for her at the second visit?
Not necessarily. It really depends on the intervening events and what transpired.
Okay, so that particular point is not crucial.
That's right.
Okay. If the defendant lied to you about why he filled the empty chamber between the first and second visit, would that change your conclusion?
Again, that might too, depending on what the truth seemed to be.
All right, well, in this case, the defendant told you he filled up the empty chamber because he was preparing to go back through Hollywood and the dangers of Hollywood, etc. Correct?
Yes.
And if the truth was that he loaded up the empty chamber because, in fact, he was thinking about killing Rebecca Schaeffer, would that cause you to change your opinion about whether or not he lay in wait for her at the second visit?
If that remained his intent up through the time he killed her, it would have a significant impact, in my opinion, yes.
If the defendant lied to you about the first encounter being pleasant, as we've discussed earlier, and that it was not so, and that it was unpleasant, that would cause you to change your opinion as to whether or not he lay in wait for her at the second visit, would it not?
Well, when you asked me before, you put a number of other things into the hypothetical and asked if that was the most reasonable interpretation, assuming a certain number of facts. That single instance, had he lied about that particular thing, wouldn't necessarily change my opinion because it would depend on the intervening period, but it would make his version of it less plausible to me.
The impact of the lie about it being a pleasant encounter the first time would have a kind of domino effect, would it not, in terms of his credibility as to what transpired thereafter?
Yes, and here I take whether it was pleasant to be a shorthand for whether he left there joyous as opposed to hateful.
Yes, and that is exactly what I mean. That's correct. So if in fact he left there hateful and he lied to you about feeling joyful after that, would that cause you to change your opinion or change your conclusion as to whether he may have lain in wait for her on the second visit?
If he remained hateful without interruption, it would, yes.
And then, of course, if the defendant lied to you about why he went back the second time, and in fact he went back to kill her as opposed to what he told you, that would, of course, change your opinion as to whether he lay in wait the second time, would it not?
Yes.
With respect to the defendant's statement to you about why he filled the empty chamber between the first and second visit, do you have any independent corroboration to support what he said?
No.
With respect to the statement the defendant told you about feeling joyful at the end of the first encounter, do you have any independent corroboration to support what he said?
No.
With respect to the defendant's assertion that he went back the second time in the expectations of a pleasant encounter, do you have any independent corroboration for what he said?
No.
Then, Doctor, to draw the conclusion that you did as to those points only, you had, in fact, to believe what the defendant told you, and you did.
That's right.
And despite the fact that you have no independent corroboration for those points, and despite the fact that you know he lied to Los Angeles Police Department in the past, and to Tucson Police Department, and may have lied to Dr. Stallbert, and as you indicated earlier, did lie to you on at least one point, you do believe all of those points.
Despite his having, in the course of many other things, many of which seem to be true, told mistruths to those people, some of which were lies, I did believe him on those points, yes.
Even though you could not independently corroborate them.
That's right.
I have nothing further.
Mr. Galindo?
Thank you.
Do you want me to ask? I need to ask some questions that are not really on this.
Sure.
Doctor, you examined the defendant on the issue of insanity, is that correct?
I evaluated the case from that point of view to some extent, Your Honor, yes.
All right. Do you have an opinion as to whether or not the defendant, under the legal test in California, was insane when he shot Rebecca Schaeffer?
I do, Your Honor.
What is that opinion?
That he was not insane under the legal test in California.
Just to make sure, and I'm sure you do, but this is for the record. You're aware that in California we now have back the McNaughton rule that requires that the defendant understand the wrongfulness of his act in order to be sane. And you have concluded that he understood the wrongfulness of his act.
Yes, Your Honor.
All right. And he also needs to know the nature and quality of his act, which in this case is killing a human being. Do you have an opinion on that? A separate issue.
Yes, that he knew the nature and quality of the act of killing a human being.
All right. And you're aware that the McNaughton test refers to the defendant's ability to know these things and understand them at the time of the commission of the act. Is that correct?
Yes.
Okay. So your opinion is that when he committed this act, he was sane. Is that correct?
Yes, it is, Your Honor.
All right. Do you have any information?
That is all we needed to know. That was it. We could have heard that on day one and been done.
We discussed in chambers only.
Yeah, I missed, I think, the question.
Oh, the question was whether he had any knowledge as to what Dr. Stolberg's opinion was, through hearsay or any other source. Again, I'm not considering for the truth of the matter certain, although I'm going to consider his opinion as his own opinion. Go ahead.
It was my understanding, based merely on a comment made by Mr. Galindo, that Dr. Stolberg also thought the defendant was sane at the time.
All right. The only reason, as you know, that I'm asking these questions is the failure of the defendant to enter a plea, and under California law, the defendant must personally enter a plea, and the reasons for not entering a plea is the defect that you perceive in the extradition procedure. And I want to make sure that these issues were covered. I don't think I will inquire of the defendant in view of this testimony regarding whether he wishes to enter such a plea, but I will put the burden on you, Mr. Galindo, to inform the court at any time that he expresses that desire. Okay, thank you. Proceed. Yeah.
All right, Dr. Dietz, at the beginning of the prosecution's cross-examination, an issue was raised concerning your accepting what at least she believed was a less than appropriate fee in this case. Do you remember that line of questioning?
Yes.
And I believe that the record was fairly clear that.
Well, I'll object about less than appropriate fee. I think that as a taxpayer, the lower the fee, the better. I mean, that's certainly not my judgment.
Although I will find this rehabilitation doctrine as fruitless as your teaching.
Do you ever lecture, let's say, for free without a fee to Los Angeles Police Department, let's say, for example, celebrity personnel management seminars, academic organizations?
Yes, I have.
The inference was raised by the prosecution as well that somehow you're motivated by seeking publicity. Do you remember that line of questioning?
Yes, I do.
Have you ever had an offer for publicity, let's say, to appear on the Oprah Winfrey Show?
Yes.
Have you had such an offer to appear in the Donahue Show?
Yes.
The Joan Rivers Show?
Yes.
Geraldo?
Yes.
Inside Edition?
Yes.
Hard Copy?
Yes.
A Current Affair?
Yes.
And others?
Yes.
And have you accepted those invitations?
I did go once at the request of the Justice Department on the Donahue show, and I went once on the very first, I think, airing of Current Affair before I knew what it was. But in all subsequent invitations from any of the programs you mentioned, I've declined.
Have you ever donated your... let me go away from that for a moment.
Yeah, let's stay away from that.
The district attorney questioned you about your original contact with me or the public defender's office in general. And I believe that you did recollect that originally there was a phone call, I think about a year before your appointment, correct?
That's right.
Just so the record's clear, you never were given materials prior to your appointment in this case, were you?
That's right.
Did you ever review materials at all?
No, I saw none of the materials that I relied on until September 16, 1991.
On September 16th, 1991, that was the first time that you and I met. Isn't that correct?
Yes.
Yay! Well, wait a minute. That didn't sound like they were done with him. Oh.
And I told you that I acknowledged that caveat, correct? That disclaimer.
Yes, and that's right.
Now, it has been suggested that you have some motivation for wanting to work on this case. Could you tell us if, in fact, you were interested in working on this case?
Sure it was.
And why?
Because there are very few, thankfully, cases in which public figures are in fact harmed by those who write to them and pursue them. And that's a subject matter that I've been studying for a long time and have been interested in for 10 years. And the occasion to learn all about this case is an important one to me.
Did you have any hopes of achieving something else, perhaps some ulterior motives, perhaps, in working on this case, testifying?
I developed some along the way, yes.
Could you please address those?
Well, I think there's some important lessons here to be learned. And they are such things as the importance of taking one's mentally disordered family members for treatment and encouraging them in treatment and seeing that they get prescribed medication and the treatment that's been recommended. And I think one can learn a lesson about the advisability of giving firearms to one's mentally ill relatives, or for that matter, leaving firearms unattended in a house with multiple mentally disordered people. I think there are lessons about how to keep documents received by letter writers, by public figures. There are lessons to be learned about how those responsible for the security of public figures ought to regard their harassers and pursuers, and how they ought to investigate and monitor the behavior of such pursuers. I think there are lessons about the security of apartment complexes and about the accessibility of those who are being pursued. I think there are multiple lessons to be learned here to prevent such things from happening in the future.
Doctor, I would like to get to the opinion that you had relied upon or stated for the record during direct examination. Now, based on cross-examination, I gathered that your testimony is that based on individual pieces of evidence, say an individual letter or a series of individual letters examined in isolation, that in that process you can say that there is a possibility that there is no evidence, or perhaps even that there is no evidence whatsoever of mental illness based on that type of a view. Is that correct?
I missed the thrust of the question. I'm sorry.
To not fully express. In forming your opinion, did you, isolate the pieces of evidence, the letters, your interview, all of the evidence and materials that you reviewed? Or did you take them as a whole and in reaching your opinion?
Try to rely on the totality of the evidence.
In your expert opinion, is that a more reliable approach to take than to individually look at a singular piece of evidence or perhaps a few sentences from a letter in trying to reach an overall opinion?
Well, it depends on what opinion one is looking at, but it's the only fair way to proceed.
You relied on a multiple of factors.
I found one. I found one. Okay, there's what he looks like now. Oh, shoot, I lost it. Hang on. I found one. Okay, I need to get that off the screen. Oh my gosh.
In the way that the district attorney phrased her questions to you in terms of isn't this possible or isn't that possible, you would agree, would you not, that there are a virtually unlimited number of possibilities, quote unquote, that one can arrive at? Would you agree with that?
I don't know about unlimited, but too many to count.
Are one of the possibilities in this case, based on the evidence that you reviewed, that Mr. Bardo suffered significantly from a mental illness or a mental disorder, and that mental illness or mental disorder significantly impacted on his mental state as far as it relates to intent to kill?
Yes.
You mentioned let me back up for just a moment. You've reviewed all of the medical records from Tucson Psychiatric Institute and some of the earlier school letters. There was a suggestion, I believe, that perhaps Robert Bardo learned of this concept of auditory hallucinations somehow prior or only at the time of his hospitalization. Do you remember that line of questioning?
Yes.
Is that your opinion?
That happened?
Yes.
No, it isn't.
What is your opinion in reference to that issue?
Well, first of all, I understand how that's possible, and that the evidence here shows no use of the term voices or hallucinations before the first exposure to psychiatry, though we don't know what he may have been asked or overheard during the course of that first exposure. And that makes one consider the possibility of whether he picked up that concept and then pretended to hear voices when he had no such experiences. I find that possibility remote and not reasonable in light of the statements he made before it, the multiple clinical recordings of what he said about voices during the second hospitalization, and even his later statements. On the other hand, I think what is not so remote is the possibility that what Mr. Bardo experienced before that first exposure to psychiatry was what are called audible thoughts, which is what's known as a Schneiderian first-rank symptom of schizophrenia. Kurt Schneider was one of the pioneers in describing schizophrenia, and he thought the key feature was that of audible thoughts. It's not a term in current vogue, but that's much more like what Robert Bardo has described to me. And I think it may be that in that first hospitalization, he picked up the notion of calling these voices or calling them hallucinations and used that terminology in the second hospitalization, when all along what it's been is audible thoughts. And I think I've said this all along, that he's had some kind of internal experience that has gotten labeled at times hallucinations, and that might be the right label. But even if it isn't, it's an important symptom that he's had.
Based on the cross-examination that you've encountered in this case and any new information that you may have learned during cross-examination on this issue, has your opinion changed as to whether or not Robert Bardo did actually suffer from auditory hallucinations or experienced auditory hallucinations, perhaps?
Well, I always had some room for skepticism there, but I think on balance, the evidence still shows that auditory hallucinations would be the current way to describe the symptom he has had. And that the evidence is, of course, strongest that he had it during that hospitalization in 1985. And for the purpose of the diagnosis that I gave, all that would be required is that he have what is called hallucinations for 1 week anytime.
You mentioned the defense mechanism of splitting, and I don't know whether or not you gave a full explanation for that phenomenon or not, but you did just address that issue, at least peripherally, just a few moments ago on cross-examination. Can you give a complete description if you did not do so already?
Well, I'm not sure if I defined it explicitly, but splitting is the process by which an external object, which is technical language for person, is colored as all good or all bad. And the individual who splits external objects in that way may abruptly and suddenly shift from one perception to the other and back about the identical object. Now, it's related in some ways to the concept of ambivalence, which has had multiple definitions over the years. But one of these relationships is that a normal person who can experience ambivalence is aware of a conflict. A normal person can be aware that there are things I like about this, there are things I don't like about this. And they see that they have contradictory feelings simultaneously. In some conditions, such as an obsessive-compulsive neurosis, an older term, the individual feels conflicted about the two and may be completely indecisive because they weigh the evidence on both sides over and over and they never get around to taking any action. Well, in splitting, it moves away from that conscious recognition that there are these conflicting thoughts simultaneously. And instead, the subjective experience is of only whatever coloration is given to the object at that time. So the patient or subject who has used splitting toward some object will powerfully hate, detest, and wish to be rid of this evil external object and would be angered at anyone's suggestion that that was a good person or had some redeeming qualities, would reject that completely. However, on another occasion, when the coloration has shifted to seeing the other person as good, and wonderful, then any suggestion that that person had an imperfection would be rejected as unacceptable and absolutely wrong. There's no awareness that both are simultaneously held within the mind, because the conscious perception is only of the color that's been cast on the object at a particular moment.
Is there any doubt in your mind that that defense mechanism of splitting is present in this case, as far as Robert Bardo, mental state, is concerned?
There's no doubt in my mind that that is a predominant maneuver that he uses. It's not the only defense mechanism he uses, but it is shown so clearly in his 1984 writings concerning Mrs. Morris as he shifts back and forth in his extreme views toward her that I don't see how it's possible for him to have faked that particular symptom, which most people don't even know about, and to have carried it into his perceptions of Rebecca Schaeffer. So I think that he really has that feature of splitting.
I want to direct.
Doctor, just a moment. Doctor, what about his letters where he says she's an angel and a devil? Isn't that evidence that he was fully conscious of his feelings toward her in two polarized ways?
I think that's one of the several occasions in which he shows some recognition that he's seen her two ways. These aren't two separate personalities that don't know about each other.
Well, you said that when he is in the mode where he loves her, he will not tolerate any contrary suggestion or statement, and when he hates her, he won't tolerate the contrary, and that he's unaware of the split, by which I think you mean that he's unaware that he has these simultaneously existent feelings of love and hate. Now you're telling me that there are times when he does experience the knowledge, analogizing it to other defense mechanisms such as repression. If something's truly repressed, one doesn't know. As a matter of fact, under pure Freudian theory, aren't these defense mechanisms things that operate unconsciously? For example, the difference between suppression, which is a conscious forgetting, and repression, which operates unconsciously. Isn't the essence of them, aren't they to protect the psyche? And the reason why they are unconscious is because if you don't have to think about them, they don't trouble you.
Everything you say is correct, Your Honor, but the individual who is splitting some external object is not always on the rampage or adoration trail. That is, they are not always in some emotional peak toward the object, and may be capable of reflecting that, there are times that I think he or she's the greatest, and there are other times I think she's the worst. I wonder what's wrong with me. But they're not aware of a conflict at the moments that they're emotionally intense about this. It's not perceived as conflicted.
It's only in the times when they are not intense that they are aware that they are split or that they have contradictory feelings. I don't want to use the conclusionary term, but when they are intense, then they are not aware of the opposing emotion, and when they are not intense, they can be aware that they have two separate feelings.
That's my understanding of it, yes.
So this entire process is not completely unconscious. Sometimes it's conscious, sometimes it's not.
Well, the fact that one is doing this to people is not typically in awareness. That is, that this is an internal process that's coloring perception, so is what's unconscious. But one is conscious of the periods of great hostility and of the periods of great adoration or warmth.
But wasn't Mr. Bardo, in the letter that he wrote where he compared the victim to an angel or a devil, aware simultaneously of these two feelings?
At the time he wrote that, he was aware that he is a person who has perceived her in each of those ways.
Well, and he expresses them in a way that these two ways coexist simultaneously in her, do they not?
Or in him.
Well, of course, in him, he can't know what she's like, but his perception of her is simultaneously that she's an angel and a devil in that letter.
Or that he's not sure which.
He's not sure which. Are we talking about him being aware of a conflict in his feelings toward her, or whether or not he's aware of what she is in essence?
He's aware of a contradiction in his perceptions.
And so he's aware that he perceives her as both.
As each.
Well,
At different times.
If you get two eaches and they occur at the same time, you have a both, don't you?
Well, but they're not occurring at the same time.
Well, they're occurring in the same letter.
His recognition that he, let me put it more plainly, he could write that letter just so if he knew, gee, last week I loved her and yesterday I hated her. Even though right now I'm not feeling anything toward her at all.
Okay.
That would be a recognition
of awareness that at one time he perceived her as an angel, and at one time he perceived her as a devil. But doesn't the letter imply a simultaneous feeling as to both possibilities?
A cognition as to both possibilities.
Right, a cognition as to both possibilities. And that cognition certainly is not unconscious, is it? Or it wouldn't be a cognition.
It isn't. What's unconscious is the fact that neither of those things is true. She isn't a devil and she isn't an angel. She's a human being who's both.
Now you're talking about what she really is, and you're departing from what we're trying to get at, which is his mental state.
His mental state is not to recognize that his mind has played this trick on him of making him think that one or the other of those two is true.
Do you see that expressed in that letter, or is this something that you're adding to it by your diagnosis?
I think the letter says, I don't know if she's a devil or an angel.
All right.
It doesn't say, I'm aware that I have strong feelings in contradictory ways and I don't know how to feel.
Doesn't it imply that? Is there anything about schizophrenia that causes you to think in the way you have just stated? And if he isn't indeed a schizophrenic.
Is there anything about schizophrenia?
It causes him to not to speak in a way that in this letter that a normal person wouldn't speak. In other words, the same normal statements.
No, I think the statements can be taken to mean what they say when he writes.
Say, okay.
Yeah.
All right.
Judy, do you know if AJ was there? Did AJ tell him not to enter a plea or what? Because when Tyler Robinson, his first appearance, he didn't have an attorney yet. There was an attorney there from the from the public defender's office, but they didn't have one that was qualified for the death penalty. So he did not enter a plea at that time. So was AJ not there? Is that why he didn't enter a plea? Oh, they haven't decided. California has a death penalty? I'm shocked. I didn't think they would. They're such a liberal state. I watched Peter. Peter did an episode on a live stream on it. And there were a lot of people that had the same sentiment that I did. Somebody asked Pete if he was surprised that AJ took the case, and he said, no, not at all. And Pete said, everybody deserves a defense. Right now, he's considered innocent until proven guilty. And we have we don't know the specifics. We don't know what happened. We don't know the circumstances. So, we can't really say anything until we find out. We have to wait till the trial. So he apparently, did you see where he talked to the, I don't know where he was. I guess he was out in front of the courthouse, because reporters were asking him questions. How's your client holding up? And, is he in good spirits? That kind of crap. And AJ said, well, I don't know, because he's not here, because he was being medically cleared. And it was emphasized that the medical clearance is routine. But I don't know if that was yesterday or the day before. AJ was his lawyer, but had not seen him yet. So obviously somebody else had acquired his services. I don't know if it was his family or what, but so the whole thing is sad. And yes, everybody deserves. And this was a troubled man. Apparently, from what I heard, he had just moved back home. He'd been in rehab 17 times in the past 7 years. And that, I guess they had tried soft love, hard love, whatever, and just nothing worked with him. And then there's some, I don't know if it's a rumor or not, that he was at some party and came home messed up, and I have no idea. Of course, Newsom, and no politics. I'm sorry, y'all. I was shut up. I'll shut up now. It was during the day, and he was standing outside of like a big building, so I think it was at the courthouse. I don't know. I saw it on Peter's channel. I'm not sure where he was. It was an Instagram post that Peter was showing. So
his pursuit of Miss Morse, the evidence seems to be that he had a crush on her until she compared him, or until she made a derogatory statement about his brother Jeff being retarded. Isn't that correct?
That was one of 2 events which, whenever he thought of them, led him to.
Which was the other?
The other was an assignment that concerned book covers, that he hadn't been told about the assignment, and yet she graded it and he didn't get a good grade, and now she thought poorly of him.
All right. Now, did he recognize any similarities between himself and his brother, Jeff?
He did by the time I talked to him.
Well, at the time that he was having this crush on Miss Morse, do you know whether he recognized any similarities between himself and his brother Jeff?
I don't know if he was conscious of them.
Well, his brother Jeff, as far as overt manifestations of mental problems, is certainly more patent than the defendant, isn't it?
Yes.
The defendant doesn't run around opening and closing doors and washing his hands a la Lady Macbeth and running out to the sidewalk and back or anything like that. Could these things have escaped him?
I don't think so.
Right. And he was aware that he was a loner and not liked by people and that sort of thing.
Yes, although this was early in his oddness that he's writing to her.
Okay, but was he aware at the time that he was odd?
He was aware.
Considered odd, anyway.
Yes, certainly within that period he was.
Would he have been equating himself in any way with Jeff and saying to himself, if she thinks he's retarded, she must think I'm retarded? and therefore won't like me because she's a teacher and she likes bright people.
He's even spoken to the issue in those writings where he seems angered at her saying she likes him because he's smart, when he thinks he isn't smart and she wouldn't like him if he weren't smart.
Right. And now if she thinks his brother's not smart, he might think that she may start having doubts about his smartness, which he really believes himself to be exaggerated.
Yes.
Right. Could he be equating her feelings toward Jeff that he perceives as being either directed at him at that time or potentially directed at him when she finds out how dumb he is?
Yes.
Then wouldn't that cause anxiety and perhaps even hostility in anyone who is pursuing someone else and has a crush on them? The fear that they are going to be rejected by that person.
Yes, it would.
Right. And can't people who are pursuing somebody whom they see as unattainable for some reason start to feel hostility toward them and feel that they don't like them and they have no right to like them because I like them, etc.? Isn't that a normal thing for people to do? You understand, I'm not doubting that the defendant has mental problems, but I need to assess not only the extent of these problems, but how they impact his act. Okay? And you'll agree that schizophrenics can premeditate murder, can they? Some of them?
Yes.
Depending on who they kill and why. And you'll agree that they can lie in wait and intend to lie in wait and intend to kill.
Yes.
There's nothing about the defendant's condition that would preclude him from intending to kill Rebecca Schaeffer.
That's right.
And I think that it is your opinion from your testimony, correct me if I'm wrong, that when he killed her, he intended just that, to kill her.
At that moment, yes.
All right. The only difference you have is as far as the intent is concerned, is that you doubt that he had the intent to kill before the moment or the immediate seconds preceding that moment.
Well, I know he had that intent for a long time preceding that moment, but
Well, I'm talking about the immediately surrounding events, which we will call the second visit and perhaps the intervening period between the two visits.
that's right. I believe there was an interruption of that intent.
And the interruption of that intent doesn't that depend on exactly what he did? Wouldn't the strongest evidence of what his intent was in those moments preceding the actual killing, wouldn't the strongest evidence be a videotape of what he did just before she was killed? Or perhaps 8 priests, rabbis, and ministers who happened to observe it and swore under oath and penalty of damnation. That's what they saw. And all of them were congruent.
Well, the best would be a credible and known to be true rendition by him of his subjective state.
Well, and of course, we can't pry open somebody's cranium and look inside and see what their intent is, even at the time we're looking, let alone in the past, can we?
No, we can't.
All right, so that's really impossible. How can you say it's credible? Wouldn't a videotape of what the actions were be more credible than somebody's subjective statement of their intent?
More credible as to the actions and far more limited as to their subjective state.
But on the other hand, in this case, doesn't most of it, what his intent is, doesn't it depend more on what he did at that doorway and before he went to that doorway than it does on whether or not he's mentally ill or anything like that?
It does depend more on what he did than whether he's mentally ill.
Remember the hypothetical I posed to you before? If the defendant went to the door, rang the bell, and hid, so she couldn't see him, He came to the door, she came to the door, opened it, and as she opened it and bent over for whatever reason, either looking for somebody who may have left because the bell rang so many times and she hadn't answered it, or because she thought there might be a package someplace, then he jumped out and shot her, or leaned out and shot her, whatever. If you knew that was true, that this was actually true, wouldn't this cast an enormous doubt on your opinion that he went up there without the intent to kill and didn't acquire the intent to kill until she acted arrogant, as he put it?
It certainly would.
In fact, your opinion now would have to be abandoned, wouldn't it?
Yes.
All right. That proceed.
Along those lines, Doctor, on the issue of whether or not there is evidence, let me ask it this way. Is there any independent evidence to corroborate the theory that Robert Bardo hid after ringing the bell, or that he was hiding somehow after he rang the bell or prior to ringing the bell?
I don't know of any other.
In fact, is there not some independent corroborating evidence to arrive at the contrary conclusion? That is, that he was not hiding moments before he rang the bell and approached her apartment.
Yes, there is.
Isn't there? And that independent corroborating evidence would be by the testimony of Lynn Marta herself, who I believe you read the preliminary hearing transcript of her testimony, where she indicated she was outside of her apartment door in a car for several minutes prior to 10 o'clock in the morning, correct?
Yes.
She had a clear view up and down the street, didn't see anybody, correct?
Correct.
Approached the door, had a conversation with a neighbor, and still stayed around the door, did not see anybody, correct?
Yes.
And in fact, there was even further activity on her part, where she left her apartment, went to the, I believe, the rear of her apartment, perhaps even surrounded her apartment, entered again, and never saw anyone hiding, much less Robert Bardo. Isn't that true?
That's true.
Would that not be independent corroborating evidence to the contrary? That is, that Robert Bardo...
No, I'm going to object just because these are leading questions. I thought this was direct.
Well, it's an expert witness, and I'll allow leading questions.
Is that not, in your mind, independent corroborating evidence for the proposition that Robert Bardo did not hide or lie in wait?
I think it indicates you.
It's not a call for speculation that someone's hiding. How can you see them?
Well, as I understand the doctor's testimony, but my questioning went to the moments immediately preceding the shooting. In other words, what Ms. Marta saw in the testimony, both here and at trial, was a period of time that preceded by a substantial period the time when she went, when these events occurred, because she went back into the house and was doing things when the door rang. In fact, she was even in a different room, as I recall, than the one that's immediately adjacent to the door.
That's true. Now, as I recall, though, the time sequence we're talking about is a short period of time, matter of
yes,
minutes.
But again, I don't think the people have proven that he spent those entire 2 hours.
If AJ was there, he told him not to take a plea. Or told him not to plead. You know what I mean. He told him not to plead because everything that AJ does is a strategy, right? He has said as much. So, at least that's what I think. Because if AJ was there, everything that happened was under AJ's control. Because he's said as much in interviews about Karen Reed, right? So, I don't know why he would do that, but
or is there any substantial part of them in hiding, waiting for her to come out? There's an inference to that effect, but I don't consider that proven. But on the other hand, when we're talking about the Ward case, in which the lady and the man went up to the door, the lady rang the bell, and immediately upon the victim answering the door, he was stabbed. The time period is very short, yet that was upheld. So what I was questioning the doctor on, in terms of a period of waiting, was waiting while he's ringing the doorbell and waiting for her to come out and possibly concealing himself. That's what I was talking about. I wasn't talking about, I mean, you're free to explore this area, to pin it down. But again, your questions seem to be in response to my questions. And I'm not sustaining any objection. Please proceed, but I think I need to clarify what I was doing.
That's fine, and along the lines of the Ward case, I do feel, and of course, this probably is the appropriate time to argue the differences in facts and things of that nature. But let me approach it a different way if I could, Your Honor.
Sure.
As far as you are aware, Doctor, is there any evidence that has been presented to you thus far that you've considered, either prior to your testimony or during cross-examination, which has caused you to change your opinion that Robert Bardo's intent to kill was formed at or immediately prior to the time that he perceived some sort of arrogance or rejection on the part of Rebecca Schaeffer on that second visit?
No.
I want to direct your attention to some areas that the district attorney raised about lies, I think is how they're characterized it from.
May I have a moment? How long do you intend to go on? I would like to finish if we can.
That's what I want.
If we do finish, I will relieve the reporter of the obligation of having a transcript immediately in the morning.
I would prefer to try to finish, and I'm trying
All right,
to go
let's
as
do it.
fast as I possibly can in the time left. Let me see if I can get to this, Doctor. The issue was raised about Robert Bardo lying about the reason of he bought the book or brought the book, Catcher in the Rye. You remember that line of questioning?
Yes.
Is there another possible reason why Robert Bardo may have not remembered the reason or been as accurate in relating the reason why he brought the book 2 years later?
Yes.
And what would that be? Give us one possibility.
Well, one possibility is that he'd by that time forgotten the other explanation, which was that it was on his list of things to do, and only recalled one of two things that had really occurred.
This was, of course, 2 years or so after the event, correct?
Yes, it was.
Now, on more salient features, did it appear to you that Robert Bardo was lying to the officers when he indicated to them that he was responsible for the shooting of Rebecca Schaeffer?
No.
In fact, did you not determine that there were many instances where Robert Bardo gave incredibly incriminating statements that were true against himself? Would you agree with that?
Yes.
Does that seem consistent or inconsistent with the theory that he was somehow trying to avoid culpability?
I think it's inconsistent with the theory that he wanted to claim he didn't do it, or that he wanted to remove himself from any responsibility.
Now, you reviewed the transcript, and I believe you reviewed the actual audio tape of the interview of Tucson police detectives and Robert Bardo on the night of his arrest, correct?
Yes, I
recall
did.
that? Now, I want you to think back carefully. Did Robert Bardo ever, strike that, was Robert Bardo the one who interjected the term accidentally or accident, or was it the police?
On the recorded statement, it was the police.
How did they do that? I haven't heard it yet.
I believe, Your Honor, page 2 of the transcript, which you've been given and furnished a copy of, you can see the instance where they interject that phrase and the response that was cut off thereafter.
On page 2, starting with line 3, where the officer who is identified as W on this transcript says, Robert, we know what you told the uniformed officers. We know that you told the officer that stopped you. Okay, Zach, Bardo, yeah, W. that you went to deliver a letter and the gun went off accidentally. Do you remember saying that to him? Is that what you're referring to?
Exactly, Your Honor.
All this does is refer us back to the original statement that he made to the officers at the scene.
And I might add that the testimony presented at the trial does not substantiate that rendition of events that the officers referred to there in that transcript.
I know, Your Honor, I was unable to present that statement in my case in chief because that was a statement made, as I understood it, outside Miranda, because he invoked the minute the officers detained him at the scene. So there is no testimony on it, but there are police reports that
Well, I
would
heard no
indicate.
testimony, and I don't have any documents that I've read that indicate that
I think
there
we
was
heard,
such an interview.
exactly, that's my point.
Well,
And we did
the
have,
absence of something in the record does not mean it didn't occur when somebody.
we do have testimony from the arresting officers at the scene and at the time as to statements made by Robert Bardo, where Robert Bardo said, I shot. Well, their testimony was a bit contradictory. One said that they said, I shot that lady, or I shot someone. Another one said, I shot the actress.
Excuse me.
I heard those, but I'm sure that's not what is being referred to. Now, it may be that there was no such conversation.
Okay.
But I can't assume there was no such conversation because I've neither had testimony that there was a conversation or that there was not a conversation.
What I would
And I
do,
can only go by what's before me.
Your Honor, the defendant makes reference on the videotape to the fact that he spoke to Chief Ronstadt. That was out at the crime scene, as you've heard referred to earlier by Officer Norton and Jim Weeder, the reporter. The statements that were made to Chief Ronstadt were outside Miranda. I was incapable of admitting them unless by stipulation of counsel, which there was none. The only statement that was admissible was a spontaneous statement made prior to the advisement.
Now, I'm not going to consider anything that anybody says that he said to some officers unless it's produced and I rule that it's admissible. On the other hand, I'm also not going to assume that a conversation that is referred to in this document and a conversation that the defendant not only accepts but elaborates upon in the subsequent paragraphs did not exist.
no, all I'm asking the court to do is to read it in its entire context and not to take out the lines out of
As
context.
far as I know, never in my life consciously read something out of context.
So I didn't mean it in that.
I may have, but it's always been inadvertent and due to stupidity.
My intent was not to impugn the court's reading of the evidence, but the phrasing during cross-examination seemed to indicate or imply or raise the inference that it was Robert Bardo who interjected that phrase, and I just wanted the record to be clear. And of course, the court is going to be reviewing the entire transcript.
In this document, it's very clear that the officers are the first who said that he went to deliver a letter and the gun went off accidentally. They refer to statements that he made to uniformed officers, which are not in evidence. And furthermore, he goes on that same page to elaborate and say this is the second paragraph of his lengthy response, and when she opened the door, she looked like she was frightened or something like that. And I had everything in that bag and all, and I tried to reach for her arm, and she saw the gun and all that, and she slammed the door in she just pulled like she was scared or something like that, and she fell back, and I guess so she wasn't, she looked like she just took a bath, like she just looked because she was taking a bath or something like that. Then I'm leaving out something, and then W, how did the gun go off? Did she grab the gun? B, I don't know. It was the only thing I had. It was I wanted the gun, get it as a protection, because I had problems with black people and all, and I had warnings from them, and I just had it loaded all, and I tried and pointed it away from her to give her the stuff and leave and all, and next I know, I saw her and I just panicked and ran away.
But
That certainly is far from an assertion that the killing was intentional and contains all the elements of an accidental shooting.
I have no problem with that, Your Honor.
So we're clear. But your question seemed to suggest that there was evidence that the officers had suggested to him that it was accidental and he adopted it. And I just want to make clear that the record doesn't support that. All right.
There were some comparisons made or drawn to your attention about the Hinckley case that you worked on and also with this case. And you remember the lengthy number of similarities that you were being asked to comment upon. Now, I would ask you to tell me if these type of similarities or analysis regarding the similarities are true as far as their mental state that was involved.
No, they aren't.
Asked in a phrase in a different way, are you saying, based on the district attorney's cross-examination on this issue, that Robert Bardo and Mr. Hinckley suffered from the same type of mental disorder?
I'm not saying that. They don't. Robert Bardo is much sicker than John Hinckley.
And in the Hinckley case, was that a jury trial, by the way?
Yes, it was.
And were you asked, or were they asked to address the issue of lying in wait?
No.
Did you give any opinions as to lying in wait in the Hinckley case?
No, there was no issue.
Now, the district attorney also commented upon or cross-examined you on the approach you took, your methodology in that case. Talk to me, tell me, was the amount of preparation that you employed in the Hinckley case the equivalent of what was done in this case?
No.
Can you explain what was involved in that, the methodology, the differences?
Well, in the Hinckley case, I had more than a year to conduct the evaluation and with no other activities. In the Bardo case, I had 16 working days, along with 40 other active cases. In the Hinckley case, I had available 2 forensic psychiatrists of distinction, a distinguished forensic psychologist for whatever amount of time was needed, and all of the resources of the U.S. Department of Justice to investigate the crime and to follow up any leads that were needed to be followed up, which resulted in more than an entire file cabinet full of reports over which I poured for a total of 1,000 hours, and my colleagues for also lengthy periods of time. We had multiple meetings every few weeks or sometimes at monthly interviews. As a team, we made multiple trips, sometimes in groups, sometimes alone, to examine Mr. Hinckley over the course of many months. We had a budget that was unlimited to allow visiting all of the scenes that he had visited, to speak to anyone who could be identified as having met him or spoken with him, to read all the books that he could be identified as having read, to spend hours going through the physical evidence. And that could not be done in 16 working days.
Is that part of the reason why you perhaps as a district attorney asked why you did not take time to speak to the officers in this case or visit the crime scene?
Yes, it is.
Or perhaps even discuss with Dr. Stallberg via a letter or some other mechanism?
I think so.
And in fact, during this trial, the district attorney has had as many as 3 full-time detectives at her side to aid her in the case during this trial. Isn't that correct? You've seen that?
Objection. What's the relevance of that?
I'm going to get to that.
Well, it doesn't seem to be relevant, but
Well, we're talking-
representation that he will make it relevant.
Well, let me make an offer of proof. The district attorney has questioned the methodology.
Why don't you just question him? I don't want to get into that.
Okay. Have you had, or have we employed 2 or 3 or even 1 full-time investigator, police officer, anybody to help on these type of issues or methodology similar to what was applied to in the Hinckley case?
I haven't, to my knowledge, you haven't either.
So despite the numerous similarities that might be gleaned concerning the Hinckley case and the Bardo matter, they are two distinct and separate cases, are they not?
Yes, they are.
Not only as the methodology employed, but also as to the medical diagnosis, correct?
Yes,
And as to the legal issues as well.
that's true.
Just out of curiosity, doctor, what was the diagnosis? I'm not talking about your diagnosis now, the diagnosis of the other psychiatrists in Hinckley, the defense psychiatrist.
The defense, well, excluding the ones that weren't called to testify, the others diagnosed him as chronic process schizophrenia, as ambulatory schizophrenia, as latent schizophrenia. There were various mentions of depression.
I
And there
thought
may
it
be
was almost
one
done.
other, I think
But somehow lied to me.
Dr. David Baer eventually talked about some form of, I think he said schizophrenia spectrum disorder, basing that in part on some scans of the brain showing abnormalities.
All right, what was your diagnosis?
Of Mr. Hinckley. Both my whole team and the court's evaluating team concluded that he suffered personality disorders and depression.
Go ahead.
Thank you. But there's been, before I leave this point, I wanted to bring out one thing that I forgot. The district attorney, in beginning her cross-examination of you, seemed to insinuate that your purpose here was, part of your purpose was to write a book concerning your experience here, your work here. Do you recall that line of questioning?
I do.
Did you have some intent of writing a book concerning this case as part of your motivation for working on this case?
No.
Can you explain a little bit further what you meant when you said that it may be included in a book?
I'd finished writing a book length report on our research about 2 years ago, which got revised with a single line in a table mentioning Robert Bardo and Rebecca Schaeffer. And so there will be that inclusion when that's released. And I would expect that I will probably put in some discussion of this case in another book that I've been dealing with the publisher on for years already.
Is this a book designed for the general public?
No, although it may be, it's not going to be sold in any controlled way.
Now, during the course of your cross-examination here, many issues have been raised, or you've been asked to draw the inference in looking at isolated pieces of evidence and to render your opinion as to whether or not these isolated pieces of evidence could be determined to be normal or not normal. Do you remember those lines of questions?
Yes.
Without belaboring each individual point, is there any question in your mind as to whether or not Robert Bardo is a person who suffers from a mental disorder?
No, there's no doubt whatsoever.
And your examination of the entire evidence leads you to believe that this activity, the conduct, the letters written by Robert Bardo are the conduct and activity of a, quote, normal person, taken as a whole?
Mr. Bardo's actions toward Rebecca Schaeffer are not the activities of a normal person. Is that your question?
In essence, yes. Any uncertainty that you may have expressed concerning your diagnosis or your opinion regarding the mental disorder or mental illness suffered by Robert Bardo, can you expand on that?
Yes, I'll be as clear as I can about it. There's no question that he's mentally disordered. And what there is question about is which particular mental disorder. The one that I have no doubt at all he has is called schizotypal personality disorder. And I phrase that not exactly correctly. He has at least what would be called a schizotypal personality disorder. If what he has is schizophrenia, then one doesn't call it schizotypal. but schizotypal has
Yeah, I looked that up.
probably
I don't
9
think
different
it's here,
features,
but I looked that up
of
earlier.
which 5 would be necessary to make the diagnosis. The central point is that there's a pervasive pattern of deficits in interpersonal relatedness, and that there are peculiarities in ideation, which is thinking, appearance, and behavior. This must begin by early adulthood and be present in a variety of contexts. In other words, no single thing in isolation would count. It must be a pattern that is shown many ways. And the 9 features, of which one would have to have 5 for the diagnosis, are ideas of reference, excluding delusions of reference. That is, they needn't be the delusion that someone wrote a song for me. Feeling that a song told you your destiny would be enough. Thinking that maybe you caused someone's plane to crash by reading a postcard would be enough to show an idea of reference for this. Second, excessive social anxiety, which Mr. Bardo has. He was even afraid at age 14 to take his jacket off in class because he'd feel uncomfortable if he removed it. And of course, he's avoided people, which we'll get to in a moment. Third, odd beliefs or magical thinking. For example, superstitiousness or a belief in clairvoyance or a belief in telepathy.
Wait. I used to have really bad social anxiety. I don't anymore. I still have a little bit, but not like I used to. Somebody with social anxiety, okay, maybe I didn't have it that bad because I did get on a plane and go somewhere by myself once. I was going to say that somebody with really bad social anxiety would not get on a plane or a bus and go to another city to meet a stranger. I guess I didn't have it then. I guess I thought I had it because I did that once, but just once. But he did it a bunch of times, right? Like he went to see Tiffany and Debbie Gibson concerts, right? So if he had that severe of social anxiety, he wouldn't do that. Like, I have a friend that has severe social anxiety, and we had that Disney meetup Saturday, like where we met people that we've only talked to on the internet. And I had only ever talked to her on the internet, but like we had become friends, and I'd met her fiance in person, but we've like text messaged each other and stuff. So we knew each other like a little more personally. So, he came to the meetup and I was like, well, where is Michelle? And he goes, oh, she's sitting around the corner. Like, he wanted to stop and like, she's not psycho. Like, she's a normal person with social anxiety. And she wanted to sit around the corner and gather her thoughts before she came and met all these new people. And she's not a psycho person. So I can't imagine, like, he's psycho. I don't think he has social anxiety. If he can get on a plane and fly somewhere to go meet an actress that he doesn't know personally, that's psycho. That's not, he doesn't have social anxiety. He's just a psycho. I disagree. I don't think this psychiatrist knows what he's talking about. I really don't. I really, really don't. I wish they would just quit asking him questions and let him get off the stand. He's been up there for days, and he's not making sense at this point because he's saying stuff that cannot be true about this guy.
Empathy or a sixth sense, things that you may find books about in New Age bookstores, but which, when in this context, are symptomatic. And those are such things as his belief in a cycle, that he, upon killing Rebecca Schaeffer, would launch a new cycle, and that he would die on a particular day corresponding to the day that she would die, that he would then be reborn in 1970 and start the cycle again. I described that earlier in my testimony, and that's an example of this kind of magical thinking or odd belief, but it's certainly not the only example that he showed. Fourth feature, unusual perceptual experiences, for example, illusions. Well, some of what he's described could be illusions if, for example, the note about what was called visual hallucinations in the second hospitalization was actually placed in the right chart. That could have been an experience of illusions he had. Also, it's possible that what he said concerning the lighting at the time of his first visit to 120 Sweetser, and what he said about the appearance of Ms. Schaeffer's forehead at the time of the second visit could be illusions, but I don't know that they in fact were. So I don't know if he's really had illusions. Fifth, odd or eccentric behavior or appearance, for example, being unkempt or having unusual mannerisms. There's no question that he has that feature of odd or eccentric behavior or appearance. He showed it with me, and he showed it to many people over the years who've described it. Sixth, no close friends or confidants other than first-degree relatives. I don't know any evidence to the contrary that he's had any close friends or confidants since age 13 outside his family. So he has that feature as well. Seventh, odd speech without incoherence or loosening of associations. For example, speech that is impoverished, it doesn't say much, or it's digressive, it goes off the point, or it's vague. Those are all the kinds of odd speech that occur in schizotypal personality disorder. Robert Bardo has odd speech. I don't think anyone listening to the videotape could see it. Eighth, inappropriate or constricted affect. For example, being silly or aloof or not reciprocating facial expressions sufficiently often, not smiling or nodding reciprocally.
If you had been here, you're just rehashing. See, we're sharing a brain. If you had been here earlier. See, I said the same thing. I said if I was on this jury at this point, I would have checked out and not been like, he's not credible. Because everything he said when the prosecution was questioning him, it's like he has fought her every step of the way. But if he had been testifying for the prosecution, he would have been the opposite. It's like, because you can tell if a witness isn't being paid, like if they're not, even if they're there for the prosecution, even if they're not being paid, but they're for the prosecution. When the defense gets up and asks questions, they'll answer their questions. They won't like fight it. You can tell when they're fighting it. And he fought Marsha the whole way. Like even as far, like one time, was it yesterday or the day before? He's like, well, that calls for a legal conclusion. I was like, dude, you can't object. The witness can't object. That's a lawful objection. But the witness can't object to the question. You have to let the other lawyer object. He's just fighting her the whole way. If I was on the jury, if there was a jury in this trial and I was on the jury, I would be like, this guy's just not going to answer her questions. He just doesn't want to answer her questions. He's just fighting her or rewording her questions or whatever he can to not illustrate her point.
I think that is a feature he has, that his affect is constricted and sometimes inappropriate. And ninth, suspiciousness or paranoid ideation. There's been only a few hints of that over time, but there have been some hints of his having paranoid.
He said it. He said it. What did he say, Judy? What did he say?
Don't be suspicious. No. Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Kom, je dikke stem is op! Kom eruit! Je dikke stem is op! Je dikke stem is op!
Ideation or suspiciousness, wondering about how others would think of him is probably more social anxiety than paranoia. Wondering if his cell had been bugged is at least a fleeting paranoid thought. And there have been some other hints, but I don't think that's a prominent feature. So out of the 9, there are at least 7 that I think there's no question he has. And the last criterion for the diagnosis is that one does not diagnose this if those features only occur during the course of schizophrenia or what's known as a pervasive developmental disorder. So if he's schizophrenic, he isn't schizotypal. The question as to whether he is schizophrenic rests on the presence of particular psychotic symptoms. If they are present, then it's schizophrenia.
No, suspicious.
If they are absent and have been, then it would be schizotypal. If he's schizophrenic, then these things that are called schizotypal personality disorder would be regarded as the residual symptoms of schizophrenia, because schizophrenic patients show those features as well. And the particular psychotic symptoms that may be indicative of Robert Bardo suffering schizophrenia are whether he has had hallucinations, which if present for a week would make the diagnosis schizophrenia, no matter when that week was, even if it was a week in 1985, or particular kinds of delusions or particular disturbance of thought. I've expressed my view that on balance, I think the evidence supports the interpretation that he has had auditory hallucinations for at least a week in his life. And that alone would be enough to say that this is then schizophrenia, because he's had at least 6 months of these other things that I refer to as schizotypal features. I've expressed doubt as to whether he's actually had delusions, though he may have. And I've expressed doubt as to the nature of thought disorder that may be there. But I've seen enough fragmentation and slippage in his thoughts to think that he probably has that too. So to sum it up, I have some uncertainty as to the correct and accurate diagnosis. No uncertainty as to whether he's mentally disordered. He has at least schizotypal personality disorder.
On the issue that was raised inferentially about Mr. Bardo possibly malingering, do you have an opinion as to whether or not he has been malingering or is malingering?
Well, people have used the word malingering in varying ways.
Yes or no?
The opinion is that Mr. Bardo has been untruthful at times and has sought to mislead at times, but that he has not malingered the presence of the mental disorder that I just described. As certain as could be that he has not malingered the features that would add up to schizotypal personality disorder. It's conceivable that he malingered the hallucinations that were described in 1985. That's a possibility. I don't think that's what happened. I don't think it's likely, but that could occur. Malingering, psychiatrists are counseled to consider in the presence of particular features. One of the features that we're told we should always think of malingering, according to DSM-3R, the book I was just referring to, is that there is a medico-legal context of presentation, and that's true here. This is a medico-legal context. The other 3 features, however, are not true here. One is that the individual have antisocial personality disorder, which, in my opinion, Robert Bardo does not. A second is that there be a marked discrepancy between the individual's claimed symptoms and their actual level of functioning. And I see no discrepancy here. He has functioned as a custodian at a fast food restaurant when he's a man with at least an above average IQ. And that level of functioning is not one that one would expect considering his intellectual abilities. It is what one would expect if in fact he is suffering from one or the other of these disorders. His lack of social relations is not consistent with someone who is really all right in malingering mental disorder. It is consistent with either of the mental disorders, and similarly for other aspects of his functioning. But his occupational and social life are exactly what one expects with these disorders. They're not discrepant from the apparent signs and symptoms. Lastly, one's counseled to suspect malingering where the individual does not cooperate with an examination, and that was not the case here. He was very cooperative.
Did Robert Bardo, in your evaluation or your interview, have opportunities to endorse certain symptoms?
Yes,
in your
he did.
opinion? And did he?
Well, there are some things that he endorsed.
How much longer are you going? It doesn't look like I have a staff to think of, and it doesn't look like. Do you expect lengthy recross?
Not at the moment. Well then, you've been asked many questions about whether or not it's possible that Robert Bardo lied about this issue or that issue. I'm not going to reiterate all of the questions concerning that. But your opinion, just so that I'm clear in my mind, is that Robert Bardo was not lying to you on the salient features. Is that correct? Or am I misstating?
Well, the various things that he may have, but it's my opinion that he wasn't lying to me as he described the joy he felt after his first visit, and that he wasn't lying to me about his sequence of varying mental states during the second visit.
Very quickly, I want to address the issue concerning the reliance on the Los Angeles Police Department summary or paraphrasing of Robert Bardo's statements. The district attorney read to you a portion of a sentence indicating some evidence of intent to kill, a plan. And I'll read it. When I went to Rebecca's, I planned to wait for her and shoot her as she came out or went in. Remember that?
Yes, I do.
What she neglected to read was the very next sentence, which was, I was pissed off for her choosing that role in class struggle, but after I met her, she was a normal person, like a college student, and I was happy. In your opinion, is that an example, or does that corroborate your opinion of this dual purpose mental state that you indicated Robert Bardo had?
Well, that is consistent with what he told me as to his change of intent, the interruption of his intent after the first visit.
And the very next line, I had waited 3 years to meet Rebecca, and I didn't think I did it right, so I went back to her apartment. I rang the doorbell and she came out. Do you see that as corroboration of your opinion, and the basis of your opinion?
I do. If he had, at the time that refers to, which is after the first visit, meant to say that he failed to kill her when that was the whole point, I think he would have said that he knew that he hadn't done it right. Whereas he says he's making a judgment that he thinks he didn't do it right, meaning he didn't court her properly.
So you could take, when taken in context, that statement that has been purportedly made by Robert Bardo does not necessarily indicate an unwavering singularity of purpose concerning a plan to kill Rebecca Schaeffer.
No, I think it supports the idea that there are multiple things going on here. And he'd failed to give her the letter. and the CD.
One other point concerning the ability or inability of Lynn Marta to hear perhaps conversation or not. Just want to make sure if I understand. In that videotape, did not Robert Bardo indicate that Rebecca Schaeffer, when she was coming down the stairs, was mumbling? Was that his term, if you recall?
He said there was a time during that second visit that she mumbled. That was his term.
And did you take
that when he was looking through his bag?
That's what I thought it was, Your Honor.
Yeah.
Even though evidence of pre-planning does exist, I think you would agree that there are periods of time where there is evidence of intent to kill and a plan to kill. You'd agree with that, correct?
Certainly.
Even though there is that evidence, taking all of the evidence as a whole, has your opinion changed as to whether or not Robert Bardo had conflicting and widely held conflicting emotions that ran the gamut from hate all the way to extreme love?
No.
Thank you. I have nothing further.
I just have one question. Doctor, that statement that was read to you from Los Angeles police, statement taken from Robert Bardo, how does the statement that the defendant said he was pissed off at Rebecca Schaeffer after seeing scenes from a class struggle and meant to kill her, and then ultimately abandoned the intent to kill her when he saw her and saw she was a normal person, show that he did not go to Los Angeles, as he earlier stated in that statement, with the express intent to kill her by waiting for her to come in or out of her apartment?
It doesn't show that.
I have nothing further.
No.
This was the excuse?
Yes.
Correct.
Hallelujah!
Yes.
All right, we'll be in recess until 10:30.
Ms. Clark?
Why is there another person's picture and name on that thumbnail? He actually had 16 parts, not 15.
Oh, you didn't get that? Oh, it's not working? Battery again or what? You want to hook it up electrically or what? There's a problem with the machine that the reporter uses, so let's wait till that's resolved. It's working again. Fantastic. All right, the Bardo case, both counsel and defendant are here. All right, you had a motion, Mr. Galindo.
Yes, Your Honor. I wish to make a motion for what is commonly referred to as a jury view.
Right.
We have had some discussion at sidebar concerning this. The reason that I am requesting this view is in light of the testimony and the court's comments concerning what appears to be a very critical piece of evidence, and that is whether or not there was any conversation, as had been indicated by Robert Bardo in the videotaped interview, and that whole sequence of events. Also, there was some...
Let me clarify the position. There is no evidence before this court that's offered for the truth of the matter asserted that there was any conversation. However, the court, in denying your motion on 1118 to dismiss the special circumstance of lying in wait, relied on certain things that Ms. Marta had heard and had not heard. So the reason I find it critical is I need to determine whether or not she was able to hear or would have heard certain events if they occurred. So with that in mind, proceed.
in light of the court's comments now and yesterday concerning that issue, it appears that that tends to be a critical piece of evidence in that the court, I believe, is going to be forced to make certain assumptions or make some inferences, or will be asked to draw some inferences concerning her testimony, not only at the trial but at the preliminary hearing, and also to whatever extent they were contradictory based on Officer Andrews' testimony regarding Lynn Marta's statements. So it appears that that is a critical piece of evidence. Not only that, also as to the inferences that the court is being asked to make concerning the lighting, what Rebecca Schaeffer might have seen versus silhouette versus whether or not she could make out some features, that type of a thing. So it appears that we are at a critical juncture here. And now, rather than speculate or draw inferences, I felt that it would be more appropriate on this critical issue to actually go down and see firsthand what Ms. Marta would have been able to hear or not hear, and to take a look firsthand at the visual scene at the time, vis-a-vis at the time Rebecca Schaeffer would have made her observations, whether or not it was a silhouette or the lighting would have been sufficient to make out features along those lines. And the court is aware of the issues that we've been raised since we discussed at the sidebar. So for those reasons, I think it would be very appropriate to take a look so that we don't have to make assumptions, we don't have to draw inferences.
I have no problem taking a look. The problem is that on an issue of this importance, I would not accept your waiver of the defendant's presence, which you offered yesterday at the sidebar. I am, however, concerned with a number of matters, the least of which is the logistics of, at this late date, arranging for the entire court staff, the defendant, deputy sheriffs, to go out for a court viewing. I'm also concerned with the defendant's reaction to going to the place where this crime occurred. There's a further difficulty in that me trying to listen to people walking down the stairs and perhaps people talking at the doorway with the door open would not be a good test, because I have an unusual hearing defect in that my ears are relatively insensitive to sounds with low frequency and relatively hypersensitive compared to the average person to sounds of high frequency, which I believe is about the opposite that most people have. And so, since we're talking about listening for sounds through a closed door, I would imagine we're talking about sounds of low frequency. So me being there, but I think these are important issues that.
Oh, I forgot what I did last time to fix it. Was it that?
Was any conversation. However, so
that we don't have to make assumptions. We don't.
Experiments you deem appropriate at the scene, and then have someone testify as to what they could hear and could not hear. Let me tell you that I don't see the lighting conditions as nearly as important as what people could hear. We have this crime occurring at approximately what time? 10
o'clock.
10 o'clock, all right. As I understand, as my recollection, and correct me if I'm wrong, about Sweetser Boulevards is something I've been familiar with since 1960 or so. It runs north and south, all right? At 10 o'clock, the sun would be behind the building. However, in the summer, it would be higher in the sky. And there would be more backlighting. The backlighting would all be reflected in diffused lighting, but it would nevertheless be backlighting. And the if you go out this afternoon, the sun will be west of the building, and that will give it more backlighting, but you could get some general idea. But again, if there's a harsh conflict between the two investigators as to what they heard or did not hear, then I would reconsider my decision not to go out. But at this point, I think it's counterproductive, considering all the things I have said.
May I ask the court to perhaps explain in greater detail your concerns on Mr. Bardo being present there at the scene?
I have no idea what his reaction would be to being in a place that has and has had a great deal of significance to him.
The court concerned that he would not.
I don't know.
What the fudge? Stop it!
Sounds with experiments you deem appropriate. We have this crime occurring at approximately what time? 10
o'clock.
10 o'clock, all right. As I understand, as my recollection, and correct me if I'm wrong, about Sweetser Boulevards is something I've been familiar with since 1960 or so. It runs north and south, all right? At 10 o'clock, the sun would be behind the building. However, in the summer, if you go out this afternoon, the sun will be west of the building, and that will give it more backlighting, but you could get some general idea. But again, if there's a harsh conflict between the two investigators as to what they heard or did not hear, then I would reconsider my decision not to go out. But at this point, I think it's counterproductive, considering all the things I have said.
May I ask the court to perhaps explain in greater detail your concerns on Mr. Bardo being present there at the scene?
I have no idea what his reaction would be to being in a place that has and has had a great deal of significance to him.
Court concerned that he would not.
I don't know. To me, as you know, I just recently helped subdue a defendant who reacted under the most unusual circumstances by punching his lawyer. And I have no idea what he would do.
Well, let me just state for the record that
if you're trying to get the impression out of me that I think he's crazy, you will fail.
I don't think that would be an appropriate term.
Okay.
I think Robert Bardo's mental illness has been stated adequately on the record as far as the defense position is concerned. I would like to state that as far as the defense position, we are less concerned with Robert Bardo being present and more concerned with actually being there, at having the event occur so that we can see at first hand what.
So we can see, or you can see.
So the court can see.
So the court can see?
Exactly. In other words,
as I said, if there's a conflict, hopefully the two investigators who go out, if you adopt my suggestion, will have good hearing and will agree as to what they heard or did not hear.
Okay.
If there is a disagreement, I said I will reconsider my decision not to go out there, and probably would go out there.
Then I'll adopt your suggestion.
Let me put something on the record, Your Honor. I think I've been very clear and consistent in my accord with counsel's suggestion that there be a viewing. I have no objection, but I do have certain concerns about the situation that is now going to occur with having the two investigators go out to the crime scene. And I am not objecting, but I want to indicate the following concerns with respect to how their forthcoming testimony may come out. And that is this: we are going to have, of necessity, a difference in hearing ability, okay, between the investigators as well as between them and Lynn Marta. We are going to have a difference in attention and focus.
with each of the investigators, as well as what Lynn Marta's was. We are going to have a difference in the willingness to perceive what occurs at the doorway between the investigators, perhaps as well as what it would have been with Lynn Marta. We will also have a difference in the familiarity with the location and what sounds at the front door sound like from inside the apartment between both the investigators and Lynn Marta. And finally, we also have the problem of recreating the conditions that were in evidence at the time of the crime in terms of the sound, because she said it was a very quiet morning. If we go out there in the afternoon when there's lots of traffic and noise, we have not even come close to recreating the situation. So what I'm talking about is the weight of the testimony to be accorded to both investigators that ultimately do go.
I can't believe testimony until I've heard it.
I understand
And
that.
you feel free to, each of you, if you're not satisfied with what the other side is doing, do your own experiments. And make note of any noise that is there, and et cetera. And I'm aware that it appears to me that according to Ms. Marta's testimony, that she was attending to the noise because she was walking, according to her testimony, at the same time toward her door as Ms. Schaeffer was walking toward the front door, and was aware of these things. And I'm taking all this into account. And
But without getting into the arguments,
nobody's arguing.
Well,
Yeah.
I disagree with
You
what
both argued, but I don't see it as argument.
I share Ms. Clark's concerns about the attention and focus to the noise. I know that the court now, based on what you just stated, feel that Ms. Marta was focusing apparently on the noise. I take issue with that.
She testified that she was focusing on the noise because they were paralleling their path, and she had a mission, so to speak, to inform Ms. Schaeffer regarding her paper.
She was also focusing her attention on other things, if I remember correctly, but I guess it would be more appropriate to argue those areas at the time of the closing. But nevertheless, in light of the court's ruling on my motion, I do wish to avail myself of the other alternative, which you suggested, which is I will attempt to send an investigator to there, and I will be there as well, and we will conduct whatever experiments we can. I'm going to try to do it today as far as the sound.
Maybe we could even get the testimony of the investigator.
Well, I don't know. I can't represent that I can do it that quickly. We do not have the same resources available, and I think we've made that clear to the court during this trial.
Oh, just to have an investigator go to the scene and then come in and say what he saw or heard?
Mr. Galindo, I told you what my tentative ruling would be yesterday at the sidebar. I said that I was not inclined to go out there, but suggested that both of you get together with your investigators and see what appropriate experiments could be done.
And I've taken steps to do that.
No, right?
And I
Haven't been successful yet?
I'll know when I go back upstairs.
I have not contacted Ms. Marta. I was wondering if counsel had done so.
No, I made it a point not to contact Ms. Marta because she is not what I would call a friendly witness as far as the defense is concerned. And I think that's a fair statement.
Marta was the lady that lived in the apartment next to Rebecca Schaeffer's. She heard the buzzer in Rebecca Schaeffer's apartment. So what they're going to do, how many years is this after it happened? 3? Do they even still live? Does she even still live in that apartment? Are they going to go knock on some stranger's door and say, we need to get into your apartment to see if we can hear the buzzer if it rings in the next apartment over? So what they're going to do is they're going to have investigators, I'm assuming one from the prosecution and one from the defense. I don't know. They're trying to figure out how they're going to do it, I guess. They wanted the judge to go do it. But apparently he's got some hearing problem and he don't think he can do it. So I guess they're just talking about how they're going to do it. I don't know why they're belaboring this point. It's ridiculous. Just do it. They should have already done it. That's part of preparing for trial, is to do experiments like this. Like, remember in the Karen Reed trial, all the experiments were done beforehand so they could present it during the trial? That's how you prepare for trial. Like, and I think they also said they were going to see if she could see his silhouette through the door. And so they're talking about the time. Like if they go out at a different time where the sun is going to be shining. So like if they go out at a different time, the sun would be in a different place. So that would determine, like if it wasn't in the same place as it was when he was standing there, it wouldn't show his silhouette. People, get your act together. Am I just spoiled because I live however many 30 years later, whatever, and courts have more of their act together now? Like, I don't understand why this is such a big frickin' deal.
I always felt it'd be more appropriate that Ms. Clark contact her. I think she'd be much more successful. And
Oh, I'd be delighted to. I mean, we're talking in a vacuum here about going out there, and we don't even know if she's there.
Right, you're talking in
Find out,
shut up.
one of you, last night, but
I'm sorry.
why don't we take a recess, stay down here, and you can go up and find out whether you have an investigator available. You can call Ms. Marta and find out if she is available. Give her a little time to ready herself and whatever else she needs to get ready for the visitors. I don't want to intrude on her unannounced or anything like that, of course.
I do think Ms. Marta was aware of this issue and the possibility of this occurring. I believe that to be the case.
I have no idea.
I think that council raised
She
it.
was here. The day she was here. She was here because you were going to make the motion. He had notified you, and yeah.
But then he changed his mind, and I had notified her that it wasn't. So, as far as she knew last, it wasn't going to happen.
No.
So,
A few minutes then?
You want to do something else for a while? I think it'd be better if we took the break right now and found out what we can do.
What? Be right back. And then you make a call.
Oh, okay. Okay, we're not going to break for the lunch hour then. We're going to just take a brief break and see what we can arrange. Is that it?
We're not breaking for the lunch hour now, but we will break for a lunch hour, yes.
At some point. I just want to make sure.
Another
I'll
instance
make the
of
call
time
here.
contraction. Courts take an hour and a half lunch.
As opposed to dilation. 2 hours. Let's call.
You contract. It was Bardo and Sure.
Yes, from the defense standpoint, we will definitely have an investigator available, and the investigator is available right now.
Any news on Ms. Marta?
No, Your Honor, I left word on her answer phone and telling her to call me back. As soon as she gets the message, I told her that I had to hear back from her immediately. It was on order of the court, and I think I made it very apparent that it was urgent and official. And I left a number of this court as well as my office.
I take it from when she came and went on the day of the incident that she has irregular hours, is that correct? Or-
Yes, yes. She doesn't work a 9-to-5 job. The only thing I would ask is if the defense does not have any further testimony, and this would be the conclusion of the defense case, perhaps I could call, all I have for rebuttal is Detective Coulter for 5 minutes of testimony. And I will not be calling.
Mark and introduce some documents also.
Yes, that's
And the tape.
Yes.
We could do that. What number does she have, Ms. Clark? Ms. Marta, what number does she have to call? Your office?
Yes, my office and this court.
And the court, okay.
And the court.
All right. I guess we can't do anything at all without her, except for what we just discussed.
I think her suggestion was a good one. We can go ahead and proceed with the understanding that we will have further testimony.
Either side can reopen on any issue.
Okay.
Subject, of course, to an offer of proof. All right, go ahead.
Well, then, at this point, I will mark as defendant's next in order the audio tape.
Okay.
Yeah.
J, K.
K, I believe it is K. The audio tape of the actual interview between Tucson police officers and Mr. Bardo.
Do you want to play that in open court, or do you want me to listen to it?
I don't think it's necessary to play it in open court. I do think it is important for the court to listen to it because the issues surrounding the type of the speech patterns and of Mr. Bardo, I think, play some importance. That's your speech.
Okay, that'll be defense K.
Also, defense next in order, which has not been previously marked. Defense L, the videotape of the second portion of Dr. Dietz's interview on September 24th.
Well, you want to introduce that into evidence. I thought what we were going to do was just to rely on Miss Dr. Dietz's description.
If the court doesn't feel it needs to look at it, that's fine.
Well, that's...
I would prefer that the court, I'm going to bring down a television set, and I will be asking the court to view the videotape during closing argument. And I would make the video machine available to the court so that it can view it, the tape on its own.
How long is the tape?
It's close to 2 hours. It's not 2 hours, but it's close.
I probably don't have the time today to look at it.
I don't think there's any need to do that. Let me explain, Your Honor. I would like to make the tape and the television available to the court to examine it at its leisure. With respect to closing argument, there are simple, very brief snippets that I wanted to point out.
Well, you're talking about the court doing a whole lot of things at its alleged leisure. There is an enormous amount of material to read and correlate. I quit taking notes during Dr. Dietz's testimony because of the daily. I found that the daily was much more naturally helpful. There are several volumes I need to go over, and I'm just wondering when you're going to argue this, folks.
Seems to me that next week is when we're going to argue it. Either Monday or Tuesday, I would think.
I would think so.
Monday?
Monday's fine. It'd have to be in the afternoon, though. The calendar is very heavy Monday.
Can we hold off on that just until we find out what happens here on?
Yeah, sure.
Okay. Well, then we're back to the original marking of the videotape.
Yeah, I was just wondering why you were marking the videotape. All right. Okay. That'll be L. Defense L. And I don't believe that this Arizona transcript has been received or marked, has it?
No, that's going to be my next.
Okay. Are you going to supply another copy?
Yes, I am.
Yeah, okay.
Could we have the stipulation now or the agreement now that I marked that transcript and substitute it so we don't have to go back? Okay.
Yeah. When are you going to furnish me with the other copy?
In about 5 minutes.
Oh, fine. Well, okay. We could always wait for that to come.
Fine. I will now move into evidence, defense exhibits A through L.
I have one objection, the same one I made earlier about the school report. It's just, I don't object to very much in line of these things, Your Honor, but this is just a lot of hearsay from so many different unknown sources that I think its reliability is virtually nil. The court has before it the substance of what that synopsizes, basically. And I think that in view of the fact that we have no way to ascertain the credibility, accuracy, or credentials of the sources that contributed to it, I think that it does not rise to the level of a piece of evidence that should be considered by the court.
Well, are these being offered for the truth of the matter stated or as a basis for the expert's opinion?
They're being offered as a basis for the expert's opinion so the court can help.
But there's no foundation to admit them as business records, hospital records, or anything else.
No,
As a basis for the opinion, I'll consider them, and naturally, the things you mentioned in your objection go to the weight of them, especially when it comes to the conclusions of someone that is, in other words, I'm still not considering them for the truth, but rather for how much weight to give to them as the basis of the doctor's opinion. All right? Okay. So the objection's overruled.
They are admitted into evidence.
And they are admitted. All of them. All right?
Then at this point, the defense will rest.
Subject to any testimony that you wish to present on whatever happens at Ms. Marta's location.
Yes.
Correct?
Yes.
And, okay. I take it from what you said that neither side intends to call any further psychiatric witnesses.
I can only speak that I was planning on calling a psychiatric witness in anticipation if Ms. Clark were to call.
Yes, and you've said that, and I don't know if it's in the record, but now it is.
Yes.
Okay, and you're not calling anybody?
No, I'm not.
All right, I need to tell the reporter that the daily is off now. Okay.
Detective Coulter, tell us who you are.
My name is Paul Coulter. I'm a detective with Los Angeles Police Department.
Has he been sworn?
I believe so.
Yes, I am.
Yeah, okay, let's consider you still under oath from the original swearing. Is that understood?
Okay, yes.
And you're one of the investigating officers on this case, are you not?
Yes, ma'am.
And have you been working on the case since its inception on July 18th, 1989?
Yes, ma'am.
Now, when did you make your first contact with this defendant?
It was on July 20th, 1989 at the Pima County Jail in Tucson.
And at that time, did you take the statement from him that we have been discussing in court, which has been marked as defendant's, I don't know which letter that is, Your Honor.
My copy is marked.
Neither is mine. Does counsel recollect which letter was assigned to the copy of the police report?
No, that was submitted by the district attorney.
Yeah, that's what I thought. Now, I'm not too sure you marked it.
But, Your Honor, I submitted it to counsel at his request to submit to the court because he indicated he wanted both.
I think it was submitted to the court and handed to me, but I'm not sure it was ever marked as an exhibit.
We can,
Maybe defendant's M?
yes, we can resolve it that way.
All right, defendant's in. In fact, I'll mark my copy, which is not the copy in evidence of that.
Sir, I'm showing you a copy of this report that's now been marked as defendant's M. Do you recognize that as being a copy of the report that you prepared?
Yes, it is.
And this, the copy of the report taken from Robert Bardo on the date of July 20th, 1989.
It is it's a summary of his statement taken that day, yes.
Let me ask you first, sir. At the time that you took this statement, you were in the Pima County Jail with the defendant?
Yes, we were.
Have you been present in court when the videotape of the interview conducted with Park Dietz on September 24th, 1991 was shown?
Yes, I was.
Did you watch the entire tape?
Yes.
Did you also watch the second tape of the defendant's interview with Park Dietz done on September 24th, 1991?
Yes, I have.
Can you tell me, sir, based on your observations of the defendant on July 20th, 1989, whether you saw any marked difference between your observations of the defendant on July 20th, 1989 and the defendant's demeanor on the videotapes that you saw, which were done on September 24th, 1991?
The day that we interviewed him in Tucson on July 20th, he spoke in much the same manner that he did on the videotape. The only difference is on the videotape, he's a little bit more animated and his speech is a little bit more rapid. When we talked to him in Tucson, he was more sedate. His speech was slow. He was very cooperative at times. While I was writing his statement, I would ask him to pause, and which time he would for me to catch up with my writing.
Did he ever appear to look over and check with you to make sure that you had in fact gotten down what he had said?
Yes, he did.
Did he do that on several occasions?
Yes, as he was making his comment, I was trying to take as much of him as I could, verbatim as he was writing. And there were times I had to ask him to wait for me to catch up. And he would look over, and as I finished, he would say, "Did you get it?" And then we would continue with his statement.
So as near as possible, would you say that you are not a court stenographer, but as near as possible, was it a verbatim statement that you took?
As humanly possible as I could make it.
Now, sir, did you accompany me to interview Lynn Marta at her apartment on October 18th, 1989?
Yes, I did.
And during that interview, did we go over the facts as she testified to them in court today? Not today, in this trial.
I wasn't present for her testimony at court that day.
You were present, though, for the preliminary hearing, were you not?
Yes, I was.
All right. Did we go over the events that transpired as she perceived them on July 18th, 1989, during the interview we had with her on October 18th, 1989?
Yes, we did.
Do you recall her preliminary hearing testimony?
Yes.
To the best of your recollection, sir, do you recall any difference between the statement that she gave us on October 18th, 1989, and her preliminary hearing testimony in December of 1989?
No.
At the time of our interview, did she inform us that she heard no conversation transpiring between Rebecca Schaeffer and anyone else at the door prior to the shot being fired?
That's true.
At the time that we interviewed her, sir, do you recall where you were?
We were inside of her apartment at 120 North Sweetser.
And were you seated in the living room?
I was standing in the living room.
And as she spoke and explained the acoustics of the apartment and how easy it was to hear things in the hallway and at the front door, were you paying attention to listen to sounds and see if you could perceive things from that vantage point?
Well, yes, I was. She has French windows on the front of her apartment that were open at the time.
At the time of our interview?
Yes.
And also at the time of the crime?
Well, I object to that. I don't believe that there's been any evidence which indicated that her windows were open at the time.
Yes, there was.
She testified that there was, the windows were open. As a matter of fact, she testified that through the open window, she heard running footsteps after the shot.
French doors were open.
Well, I don't know about French doors, windows, where I heard.
Front windows, yes.
Yes.
Okay, then maybe it's a question
I
of
think what he
semantics.
said was French windows.
Okay, then I misheard. I
Well,
thought he said French
for
doors.
photographs and.
Well, we're going to be going down there anyway, so.
Right.
Tech to just swing open.
Window.
French windows.
Yeah. That's what I took French windows to mean. Yeah.
Then I misheard.
And during the interview that we conducted with her on October 18th, 1989, do you recall that she told you that she was uncertain as to whether or not she had heard Rebecca Schaeffer's buzzer?
I recall her being certain that she heard it in the back
At the time of the interview?
at the time of the interview.
Okay. Do you recall her testifying that she heard Rebecca Schaeffer walk down the hallway?
Yes.
And do you recall her telling us also during this interview that she paralleled Rebecca Schaeffer's footsteps as Rebecca Schaeffer walked down the hall on the outside?
Yes.
Do you also recall her testifying that it was, not testifying, during our interview, stating that it was a mere second or split second after Rebecca Schaeffer passed her door that she heard the shot ring out?
Yes.
And you recall her also telling us during that interview that she heard no voices or conversation at any time prior to the shot being fired.
That's right.
Do you also recall her telling us that she was paying attention to Rebecca Schaeffer's progress down the hallway because she was considering telling her that she had thrown away her newspaper inadvertently?
Yes, that's true.
I have nothing further.
Gross.
When you spoke to Lynn Marta, was she aware of the importance of her testimony on this issue?
Well, I'm sure she was aware that it was a serious matter. I don't know what was in her mind as far as what that meant at the time.
Well, through your conversation and your interview with her and the questions being put to her by the district attorney, wasn't it discussed the importance of this piece of evidence as to whether or not she heard something or did not hear something?
Well, what we were doing at the time is basically going over her original statement to verify what she had told us originally.
So again, I would ask you, was it discussed based on your recollection with her, the importance of discerning whether or not she heard something or didn't hear something as far as a conversation? Wasn't that discussed with her?
Well, yes, she was told it was important that if she remembered something to let us know. If she didn't remember.
How long was your conversation with Lynn Marta on that day?
It's probably about 30 minutes or so.
Okay. And are you aware of that, as the investigating officer in this case, that her original statement to Officer Andrews, I believe it was that she wasn't even sure at the time that she even heard Rebecca Schaeffer's buzzer? Do you remember that? Did you review that?
I don't recall what was said in the statement at this time, no.
But you did review the statement before, correct?
Before, yeah, 2 years ago.
Show me what appears to be a statement form. It indicates Lynn Marta being interviewed by Officer Andrews, correct?
Yes, it does.
You've seen this before, correct?
Yes.
Do you discuss this with her?
Did I discuss the report with her?
Yeah.
The statement? Yes, at the time.
And does it indicate, at least here on the buzzard, whether or not she heard the buzzard? At 10:05, I believe I heard Rebecca's buzzard.
Yes.
She wasn't speaking in terms of, yes, I heard it. I knew it was Rebecca's buzzard, correct?
Not at that time.
Not originally at the time.
No.
And the date of this report appears to be July 21, 89?
That's what it appears to be, yes.
In fact, the statement goes on to say that I thought it was probably Rebecca, correct?
That's what it says in there, I believe.
Now, when you were in Lynn Marta's apartment, seated there, your attention was focused on what you could hear, correct?
I'm sorry?
You were seated there at the apartment of Lynn Marta in her living room. Is that where you were seated?
Correct.
Your attention was focused on what you could hear outside the apartment, correct?
Not entirely. It was focused on what was being discussed between the district attorney and Miss Marta, as well as what was outside, yes.
Wasn't the whole purpose of your trip there to, in essence, reconstruct in your own mind as far as what she could hear or what she couldn't hear?
No, that was not the whole purpose. The purpose was to go back over her original statement and clarify some things.
Then let me rephrase it in this way. When you were there for your stated purposes, did you make the conscious effort to listen, to see what the acoustics were like, to see what you could hear?
Oh, yes.
Okay. And for that period of time, at least, your attention was focused on your ability to hear sounds from your vantage point, correct?
Correct.
Okay. Now, you were present during Lynn Marta's testimony at the prelim, correct?
At the prelim, yes.
Didn't she testify that when she was recollecting what had occurred about her hearing certain things, her attention wasn't focused solely on what she could hear? Isn't that true?
I believe so, yes.
Her testimony was that at the time she was listening to phone messages and listening to her cat who was meowing, correct?
Correct.
And she was focusing her attention on feeding the cat and so forth, correct?
That's correct.
So wouldn't you agree that the focus of attention between you and at least the testimony of Lynn Marta were somewhat different?
Yes.
Can you clarify this? At what time she was focusing on feeding the cat and all that?
Well, according to my reading of the preliminary hearing, and we have marked it and we have stipulated the court couldn't consider that, it's my understanding that it was during the same period of time, minutes before or moments before.
Yes. Just to clarify the record, I'm aware of what it says in the transcript of the preliminary hearing, and my recollection is that when she is talking about focusing on her attention on the cat, etc., it's either before or at the time the buzzer rang. I don't recall any focus of attention during the periods when she was walking toward her door and the period when she heard the shot, other than the newspaper thing. Now, if I'm in error, please correct me.
I believe that's a fair statement.
Okay.
And I'm going to address those issues more appropriately at argument, Your Honor.
Well, I just want to make the record clear. I'm aware of what the testimony has been, but, okay.
Let me direct your attention, Officer, to your interview of Robert Bardo. You say you first met him on July 20th, 1989, correct?
That's correct.
And you say that he was cooperative, correct?
That's correct.
Just so that the record's clear, you informed him of his right to have an attorney present, correct?
Yes, we did.
You informed him of his Miranda rights?
Yes, we did.
And he told you he wanted to have an attorney present, correct?
Yes, he did.
But then you again, after he said that, you asked him if he'd still be willing to talk to you.
Yes.
Is there a reason why you just did not accept his request to have an attorney present before he spoke to you?
Well, he expressed a willingness to talk. However, he was concerned about having a lawyer present. Yeah.
But your statement indicates that when you asked him and advised him of his rights, that he said that he wanted to have an attorney present, correct?
That's true.
And you clearly did not stop at that point any further questioning, did you?
No, we did not.
Why did you? Why did you persist?
Well, it wasn't a matter of persisting. As I said, he seemed to have a willingness to talk. And basically one of his statements was, as long as you can't use this against me in court, I'll tell you whatever you want to know.
Your statement is that he made that statement?
Yes, it is.
I presume it's located on bias or some other reason, because obviously you introduced the contents of the statement. All right.
Yes, not for the truth of the matter, I might add.
As a basis.
Yes, it is offered for bias. Were you aware of the prosecution theory that at the time he was arrested by Tucson Police Department officials, that it was presumed that he had not slept for 48 hours?
Was I aware? I don't think any of us had slept for 48 hours at that time.
My question is whether or not you were aware of the prosecution theory that the defendant, Mr. Bardo, had not slept for 48 hours.
Objection. What theory could the prosecution have?
The area of inquiry is absolutely appropriate, but that was a prosecution theory at the time of this interview?
Yes.
I don't think there was a prosecutor then, was there?
No.
Let me rephrase.
Yeah.
Were you of the opinion that Robert Bardo had not slept for 48 hours prior to your interviewing him?
No.
Were you aware that Tucson police officers had interviewed him hours before your interview?
We were aware that there was an interview, yes.
Were you aware that it was tape recorded?
I believe there was mention that it was tape recorded, yes.
And when was your interview or the Los Angeles Police Department interview with Ed Bardo taped?
No, it was not.
It was not audio taped?
No, it wasn't.
How about with Philip Bardo?
No, it was not.
How about Arlene Weidrich?
Arlene Weidrich, yes.
Was there a reason? I take it that you did not choose to tape record your statement with Robert Bardo. Is that true?
It's not a matter of not choosing. We weren't working under optimum conditions. At the time, with everything happening so fast, we were flying by the seat of our pants. And I did not have a tape recorder, and I did not have access to a tape recorder.
Tucson Police Department would not allow you to have their cassette recorder?
As far as I know, they did their interview in a soundproof room that is equipped with a sensitive mic.
Did you ask them to lend you a tape recorder to see if you could tape record the conversation?
No, I don't believe I did.
Did you make any attempts at all to tape record the interview?
I didn't have a tape recorder, no.
Well, but did you make any attempts at all to try to solicit the help of Tucson Police Department in recording the interview?
No.
No? Now, you say that it was, the statements were voluntary on the part of Robert Bardo, correct?
That's correct.
And you took great pains to make them accurate, correct?
That's correct.
And you had a pencil and you had a paper.
I had a pen and I had a paper.
Okay, is there any reason why you did not have Robert Bardo sign or endorse the statements that you were attributing to him?
He has read it. He didn't want to sign it.
So your testimony is that you made an offer to have him sign it and he rejected that.
That's correct.
And you reflected that in your statement form?
No, I didn't.
Well, officer, isn't that something that you think might be important on a statement form, especially when someone has evoked the right to have an attorney present and you're claiming that it's voluntary?
Well, as far as I was concerned, he was aware that these statements couldn't be used against him in court.
And so you thought that despite the fact that you were taking down the statements, you thought they were important and that you regarded them as voluntary, you didn't think to have him sign or at least make a record that you attempted to have him sign and he refused.
No.
Why would you leave out that?
Why would I leave it out?
Yes, you're writing a report. You're taking time to be very detailed about what he tells you and about the facts surrounding this conversation. Why not include a little sentence that he refused to sign the statement? Why not?
It's possibly something that I neglected to do, but there is a page in here that is in his writing, in his drawing.
I'm talking about his endorsement of the statements that you are attributing to him. That's what I'm talking about.
That's true.
Well, why not? Why wouldn't you do that?
It's possibly just something I neglected to do.
In a murder investigation of this stature, with this publicity, with this importance, correct?
Yes.
When you were there with Robert Bardo, did you ever discuss the legal concepts of lying in wait with him?
No, we didn't. That issue hadn't even been brought up.
So it'd be fair to say then that Robert Bardo, at least at that time of the interview, in your discussions with him, was not aware, as far as you know, of the legal elements of lying in wait, both as they relate to a special circumstance allegation or as they relate to Penal Code 189, which defines murder by means of lying in wait. True?
I don't know if he was or not.
You certainly didn't discuss that with him.
No, we didn't.
In fact, you didn't even discuss concepts with him of first-degree murder, premeditation, deliberation, or any of those things, correct?
No, we didn't.
Okay. Nothing further.
Matter of fact, you didn't discuss anything, did you? You just sat back and let him talk?
Yes, sir. Yes, ma'am. It was a narrative basically like it was on the tape.
How many times did you have the opportunity even to interject questions during that statement?
Our questions were very minimal. As I said, I was writing, and when it would come to a point when he was getting ahead, I would ask him to wait and let me catch up, which time he would.
Now, you indicated you were not concerned, or you did not indicate in your report that he had not signed it, or he had refused your offer to sign the report. Was that possibly due to the fact that you never thought the statement was going to be admissible in any event?
I didn't think it would be brought up, no.
Because he had invoked his right to have a lawyer present and agreed to talk only off the record, correct?
That's correct.
In indicating that at the top of your form that he had invoked his right to have a lawyer present, you felt that it was implicit then he would not endorse the statement because the only reason he gave it to you is it would not be admissible. Tell me then, sir, why you did not feel it important to put down the fact that he did not sign the statement when offered an opportunity to do so.
That misstates the evidence because his testimony was he most probably just neglected to do that, not that he made a conscious decision that it was not important.
You know, there's conflicting evidence, I believe. I think at one point he said that the defendant did not want to sign it. So go ahead, clarify.
Did you try to include everything that you felt was important in the statement?
In the statement, just about everything he said is included in the statement.
You didn't know what was important or not at the time, correct?
No, I was just writing as he was talking.
Okay. With respect to the fact that he had asked to have a lawyer present and would only talk to you off the record, did you make a note of that fact in your report?
Yes, I did.
You noted that he had said, "I will not talk to you without a lawyer present," basically invoking his rights.
Yes.
Then why did you not put down that you offered him the opportunity to sign the statement and he refused the opportunity?
Well, as I said, he'd invoked his rights to talk. Basically, we told him, we've come a long way. There's some things we're just curious about if you don't mind talking. And he says, as long as you can't use this against me in a court of law, I'll tell you whatever you want to know. And he started his spiel.
And at some point, you offered him the opportunity to sign the statement,
At the end,
and he just declined to do so.
yes.
But you did not make a note of that.
No, I didn't.
Okay, why not?
Well, at the time, our interview was being terminated by the Pima County Sheriffs because they had to get him arraigned. Is why we had to cut our interview short. Yeah, I'm sorry.
Is that why, what I'm asking, officer, is this: why did you not put it in your report that you offered the defendant the opportunity to sign it and he declined to do so?
Well, I didn't think it was going to be brought up here in court.
You felt it was simply inadmissible, so.
I want to object to that. Now it's leading and she's testifying. at this
I think
point.
I'm just recapping his testimony. Can we have his answer read back?
I think I understand what he's saying. And I think the record's clear, so.
During the course of your interview with the defendant, sir, did he handwrite certain documents for you?
It's not handwritten, it's a drawing that he did.
Actually, did he do a couple of drawings for you?
He did one drawing.
What drawing was that?
It was a drawing of the cylinder of the gun and the way he loaded it.
And did he indicate in that drawing what was the grain weight of the bullets that he put in each of the cylinders?
He indicated five chambers had 110 grain, one chamber had a 158 grain.
Did he also make a drawing for you of the alley where he ran?
I don't recall a drawing of the alley.
Do you recall, was one of the reasons you wanted to talk to him off the record, to find out where the gun was?
Yes,
And did you ask him about that?
yes.
And what did he indicate to you?
He stated he threw it out to the left and motioned his left arm out like this, just throwing it out.
And he described the area in the alley where he had thrown it?
Yes, he did.
Before the preliminary hearing, Detective Coulter, did we go out to re-interview all of the witnesses that had earlier been interviewed by the police?
We interviewed quite a few, yes.
Lynn Marta was one of them.
Yes.
At the time of the interview with Lynn Marta, did either you or I inform her that the defendant was claiming to have had an argument with Rebecca Schaeffer at the time the shot was fired?
No.
To the best of your knowledge, did she have any idea that that was the case?
Not to my knowledge, no.
And even through the preliminary hearing, to the best of your knowledge, sir, did anyone on the police force or myself inform her of that fact?
Not that I'm aware of.
So to the best of your knowledge, sir, did she know that that was what the defendant was claiming at the time of the preliminary hearing?
I'm going to object that to this statement of the evidence. The defense claimed, or Robert Bardo claimed at the preliminary hearing that there was an argument. That's simply not true. And you have a copy, Your Honor, of the transcript of the preliminary hearing.
That's not what I said. I am saying at the time of the preliminary hearing, did Lynn Marta know that the defendant had claimed to have had an argument? If he didn't make the claim at that time, then she obviously couldn't know it.
I take it the question goes to as far as he knows, and I take that to mean did he ever tell her or know of anyone else who told her that the defendant was claiming to have had a discussion with the victim just prior to the shooting. Is that what you're asking? Okay.
Correct. As so phrased, as the court has phrased it. Delete argument, put in for conversation or discussion. To the best of your knowledge, did anyone inform her that the defendant was claiming to have had a conversation or discussion with Rebecca Schaeffer at the time of the shooting?
Not that I'm aware of, no.
So to the best of your knowledge, did she even know that at the time she testified at the preliminary hearing?
I don't think so. I don't know.
I have nothing further.
Let me ask some questions. When you were sitting there and you were paying attention to the noises in the apartment, Did you hear anyone walk down the hall that was adjacent to the front door of Ms. Marta's apartment?
No, I did not.
All right. Did you hear any sounds at all, either emanating from the outside or from the hallway?
Just traffic of vehicles on Sweetser.
Okay. Good.
Just a couple of one of the reasons that you wanted to interview Mr. Bardo, in addition to the reason that you put forth to the district attorney just now, one of the reasons was to obtain as much incriminating information and statements as you could. Isn't that true?
Oh, well, no, it's not.
Well, detective, how long have you been a detective?
I've been a detective for 3 years now.
Okay. And you're especially assigned to homicide, I take it?
Yes, I am.
Okay. When you were interviewing Mr. Bardo, you did know that he was a suspect in the case, did you not? Otherwise, you wouldn't have been there, obviously, correct? So as part of your normal practice, wouldn't you be trying to elicit as much information that would be helpful to the prosecution as possible?
That's true.
Wasn't that one of the reasons you were there?
Yes, it was.
Is it your testimony that Robert Bardo claimed that he had an argument with Rebecca Schaeffer prior to the shooting? Is that your testimony?
No, not that he had an argument, but that they did have conversation.
Well, at what point in time? At the time of the interview? Objection, that's vague and ambiguous. At the time of their interview or at the time?
There has been testimony that the defendant said that he was there twice, and both times he talked to her.
I said the shooting. I thought I made that clear.
No, I'm asking.
I'll reverse. My question, officer, went to whether or not Robert told you that he had either an argument with Rebecca Schaeffer prior to the shooting on the second incident.
If he told us that he had an argument?
Yes, if you're claiming that he told you that he...
No, I never claimed that.
I have nothing further.
My objection went to, I thought the defense attorney was asking him whether the defendant ever claimed that he had had an argument. Well, he did at one point, but certainly not at the point this was interviewed.
But I'll withdraw the previous question.
That was an objection?
You mean the one that was answered?
No, the one that she had objected to. I'm objecting to her testifying, basically.
I'm not testifying.
Just clarifying what her objection was, as I understand it. And if she tries to testify, I will not take it as testimony, believe me. All right. May this witness step down and at least be excused on this call to the stand?
Yes, Your Honor.
All right. I take it that there is nothing left to do from either side other than resolve this issue of the possible experiments at the scene.
I do have transcript. I don't mark this defense. I think next number is N, I believe.
N, all right, N, the transcript of the interview by the Tucson police that's in a gray cover will be marked defense N. Okay. Yes, you may. Do the people rest subject to any testimony on the issue that we've been trying to resolve in terms of somebody going out there? All right. Is there any rebuttal other than any defense rebuttal other than whatever may arise out of a visit to 120 North Sweet?
At this time, there's no rebuttal, Your Honor.
Okay, so basically, except for that, the case is over.
Yes.
Argument, of course. All right. Let's, why don't we trail this matter over until 2 o'clock? I would like a report. I'd like to give the staff a lunch break so they can not only have lunch but work on whatever they need to work on. But I will be here, so I would like to know at the earliest possible opportunity whether you're going out today, whether the arrangements have been made, etc. Okay, and I'll set this matter for 2:00, and I'd like you to be here unless you inform me previously that you have left.
Fine.
All right, and my chamber's numbers is 46982. Okay. All right.
Can we talk sidebar for a moment? Sure.
You guys, Matthew works on Guardians of the Galaxy roller coaster. Like, he fixes it. He works on it. He's not like someone that just like puts you in the seat and makes sure you're left. Like, he works on it. Like, he fixes it and stuff. He's the person that keeps us safe. He's amazing.
People versus Bardo. All parties are here. So,
I had a message relayed to me. I stepped out briefly at the lunch hour. Within 1 minute before I came back, apparently
Well,
Lynn Mark called a message saying she's on the road. She'll try us again, and that she's leaving for New York Monday afternoon. And I expect that she will call me this afternoon, and at that point I will arrange to have her there so that we can come over, and I want to do that this afternoon.
all right.
That's my hope. If not, then Monday morning.
I don't think there's any hope that we can get any testimony in today.
Probably not.
More testimony.
Agree with the district attorney's assessment.
Yeah.
However, I do anticipate that any testimony on this issue would be somewhat brief in quotes.
I would imagine it would be brief. And we certainly can do it Monday easily. In view of that, can we plan on argument on Tuesday?
Yes.
Yes.
All right. Okay, I'm going to continue this then until 10 o'clock Monday. Okay?
Okay.
All right. 10 o'clock then.
May I ask that council keep itself available by the phone for the remainder of the day, at least until 5 or 5:30, so that if we can set it up to get out there today, we will.
Might as well address this issue. Is there any problem that either of you would have getting there, or your investigators would have? Yeah, I would prefer both the lawyers be there. I'm just telling you my preference. Do it any way you want, but you know what's important and what's not important. I'm particularly concerned with the ability to hear conversation with the front door open through the closed door. More than the others, but obviously the footsteps, the opening and closing of the door that was Rebecca Schaeffer's, etc. Okay?
I plan to be there, and this is the case with all.
Any problem if it has to go over to the weekend?
I have no problem with that.
All right. Okay. How long does she intend to be gone, did she say?
She did not. She didn't leave a message anyway. I will speak to her, I hope, very shortly.
Okay. All right.
I'm gonna laugh if she doesn't live there anymore. Okay, next video. Why is it not playing the next video? Play the next video. Yes, continue watching. We're almost done. What time is it? It's 3. I don't think we're going to get closing arguments today, y'all.
People versus Bardo. Defendants present, both counsel.
I lost
What are we doing today?
Your Honor, we were able to, last Friday, send investigators to the scene. We did go to the scene of the crime. We did some reenactments, if you will, and we're prepared here to put on some testimony via my investigator, and I assume Ms. Clark might do the same on what occurred. Good. We would call then Mr. Agee, Your Honor.
Do you solemnly swear that the testimony you may give in part and intended for this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated in witness stand. Sir, would you please state and spell your first and last name for the record?
Rommel A.G. Rommel spelled R-O-M-M-E-L A-G A-G-E-E.
Mr. A.G., would you state your employment?
I'm an investigator with the Los Angeles County Public Defender's Office.
Would you explain briefly your training and experience?
I was a Los Angeles County Deputy Sheriff for 10 years, working the Custody Division, Patrol, and Court Services Bureau. I've been trained in investigations, general type of police investigations, and the likes. As an investigator, I've taken various training classes and seminars in regards to investigations and observations and interrogations.
When did you begin your employment with the Los Angeles County Public Defender's Office?
As of 1990, I believe. It's been approximately a year and 6 months now.
On October 25th, 1991, did you have occasion to go to the area located at 120 Switzer Avenue?
Yes.
And was I present with you?
Yes.
And anyone else?
Yes.
Who?
The Deputy District Attorney and I believe 2 of her officers and your secretary and the lady of the apartment house. I'm not sure of her name.
Lynn Martin.
Lynn Martin. She was there also.
Now, when we arrived at the location of 112 Switzer, were you able to get a layout of the apartment and the foyer?
Yes.
Now, would you describe briefly, and Your Honor, if the court would allow, he's drawn a diagram, and I think it might be helpful on the board.
Yes, sir.
I'll turn it around.
Sure. Yeah, excuse my artist. I'm not a very good architect, Your Honor. One second to get up and.
Yeah, if you want to point out, I'm sure.
So the judge can see. Would you explain to the court what you've drawn on the diagram and the distances?
This particular area, Your Honor, is the front door. Okay, as we came onto the street on Switzer, this is the front door. It's a glass door. The front door is.
Is the front door parallel with the side of the building there, or what?
It's, how can I say? Yes, it's the front door is right in front of. I believe it's there are apartments on both sides of the building, and there are apartments on top of what it appears to be.
Is there an alcove there?
Oh.
In other words, does the door go into?
Yes, there's a little entry. Yes. There, the front door opens up, and there's a little entry right there. On the sides, on the outside of the door, there are buzzers to indicate who lives in what apartment, and you have to buzz in order to get in. The person that you are coming to visit has to come to the door to open it. Okay.
Yeah, when I Magic Adventures, when I go to the park with them and they're live streaming, I ride rides with Jen that Mike can't ride because he has motion sickness and vertigo. So otherwise, if I'm not with him, she has to ride by herself on the slow rides, he's fine. But on like the roller coasters and stuff, he can't do it. So, yeah. It sucks though, because some of the rides are so much fun. But yeah, I get it. Like, you don't want to ride and then be sick the rest of the day. It ruins your day.
Like I said, this is the front door. It's a glass front door. It's a arc type door, I believe. And as you enter the door, there is a entryway here, small entry I indicated here. There's some steps that you come up, okay, into the hallway, and then you enter, and there's some more steps that you go up to the second story, I believe. I didn't go up there, but right here, there's some steps as you go up to the first hallway, and that's where Mrs. Marta's apartment is, would be to our left, I guess it would be. And that's what this information is here, okay?
The drawing that says kitchen, living room, bedroom, dining area.
That's Ms. Marta's
That's all
apartment.
Ms. Martin.
Yes,
All right.
yes, sir. Okay. We measured areas from the entryway of Ms. Martin's bedroom down her hallway to the front door, which we estimated came to 9.5 feet. Okay, 9.5 feet. We also indicated from her front door on the outside of the apartment down the hallway, from the front door to the bottom of the steps, the entry steps to her hallway comes to 7.8 feet. Okay, that's to the bottom of the step where the entryway is, okay? Now, from the bottom of the steps at the beginning of the entry to the front door, we measured at 9.8 feet, okay? Now, total from the front door, from Ms. Marta's front door, all the way down to the front door, all the way down from Ms. Marta's front door to the front entry door, measured 13.7. Okay.
You have 4 steps drawn there. Is that accurate or more or less?
More or less, Your Honor. It's, I don't know, I'm not quite sure how many steps there were, but it's a little step down, maybe 4 steps, maybe 5. I'm not
Step down or step up? I mean, which way are you going?
Well,
when you come in from the outside, do you
step
go
up. Yes, Your Honor. Okay.
Perhaps, let me clarify something if I could. I just conferred with the district attorney's officer, and I believe that the total distance between the front door, outside the front door of Miss Marta's apartment and the entry door is 13.7, I think is the total.
Yes, he said
Okay. I think the distance from the front door to the top of the steps is 7.8, and to the bottom of the steps
7.9
is 9.8. So I think this is a correction. Is that clear to the judge?
Then I still don't have the distance, since you're going to make 9/8, or is it also 9/8, both of them? You have 9/8 from the bottom of the stairs to the front door. Is that also 9/8?
No.
No, right.
To the bottom of the stairs is 9/8. To the top of the stair.
To here. From the door to the top.
Is 7.8. And I believe the district attorney indicated that's accurate.
So actually, the steps are 2 feet long, is that correct? 7/8 to 9/8.
Yes.
And so the total is 13.7 between Ms. Marta's front door and the front door of the
Front door of the building, yes. That's right. Now, so this is basically the layout, and this is the closet in her bedroom. We didn't measure that.
Now, we reenacted, did we not, on a few occasions, 3 occasions, someone walking down this hallway, correct?
Yes.
Going all the way to the, down the stairs and to the front entry door, correct?
Yes.
On 3 occasions.
Yes.
Once was with Miss Clark walking.
Yes.
The other one was a police officer, I believe.
Well, I think Ms. Clark walked twice, didn't
Okay. Anyway, it involved Miss Clark, one police officer, a lady police officer, and then one's the secretary.
Yes.
Now, just indicate, if you would, to the court, where did Miss Marta state she was at during the time that she paralleled walking with the steps, presumably of Rebecca Schaeffer?
Okay. Just where she said she started walking?
Yes.
Or the whole thing that she told?
Tell me the whole indication.
Apparently when she said she heard the doorbell, and she was in her closet here. She was in her closet here when she heard the doorbell. Apparently the victim's apartment is right next to hers, but she thought that it was her doorbell ringing because she was in this closet here getting something. Apparently she started walking this way through her bedroom, from her bedroom door, and started walking down the hallway here, down her hallway.
Go ahead.
Okay. apparently the victim was walking down the hallway as well. She stopped here.
Where the exit is?
Where the exit is,
Yeah,
this area, because she apparently was going to feed her cat was meowing or something, and she stopped to go feed her cat. Apparently, this is where her kitchen is, adjacent to the front door. This is where she.
I thought they had two questions. I thought they had two questions. Could you hear the buzzer in the other apartment? And if she could see his silhouette outside the door, why is he testifying about every single thing that happened? We really want to get to closing statements. This trial is taking forever.
The footsteps as they were coming this way, and this is where she was positioned when she heard what she said she heard. I believe this is also where I stood, Your Honor, to listen to see what I could observe.
Right.
Did you also position yourself at the bedroom?
Yes, I did.
Door?
I positioned myself here to listen as well, Your Honor, and I could hear footsteps clearly walking down the hallway.
You could hear the footsteps?
Yes.
Of the lady who was simulating the victim?
Yes, Your Honor.
Right.
Okay. Now, why don't you go ahead and resume your seat, Mr. Agee. The composition of the hallway floor, is that brick or is it hardwood floors?
The hallway is hardwood floor.
And the steps?
The steps were hardwood floor.
And then the foyer?
Were brick or tile type.
Okay. Now, let's take the first reenactment and I believe that was Miss Clark, as she was walking down the hallway. You could hear that, correct?
Yes.
And could you hear her as she walked down the stairs?
Yes.
Could you hear her as she walked on the brick or the tile foyer?
I couldn't tell if she was there at that point or not. I could only hear from the wood type of flooring.
Now, could you hear her voice as she was enunciating and asking some questions at the door?
Yes.
Okay. Now, could you hear the door latch turn prior to the door opening? Could you hear that?
Yes.
Was that distinct?
It was distinct, yes.
Was it clear?
It was clear.
Was it as distinct and as clear as the voices?
It was distinct and as clear as her voice, but not as the voice on the outside, as being clear as to what was being said.
The voice on the outside, could you make out what was being said?
No.
Could you hear the voice itself?
Yes, Your Honor.
All right.
Now, describe what you heard as far as the door mechanism and the door opening, if you could hear any sounds at all.
What appeared to me was the door it sounded like someone was opening a latch, or I don't know if it was like unlocking, but it was a click type noise.
And you could hear that click.
You could hear a click type, something being open or a door being open. It clicked. And also when the door closed, you could hear the shutter because of the door being made of glass.
Could you hear the door as it was being opened?
Yes, you could hear a door opening.
Something other than the clicking of the lock, right?
Yeah, because it kind of has a shutter to it because the door has glass on it.
What, did you examine the lock mechanism?
No, Your Honor.
Look at it at all?
I did not, Your Honor.
You didn't see what kind of a thing? Okay.
I think we could enter into stipulation on
Sure.
that. I examined it, I believe Ms. Clark examined it. It's a metal type latch that you turn to the right to unlock it, which has, okay. It's a metal latch, it has to be turned before you can open the door. So you could definitely hear the latch mechanism, and you could definitely hear the door opening, correct?
Yes.
And that was clear and distinct?
It was clear as to being the door being open, yes.
And it was as clear and distinct as Ms. Clark's voice?
About as, yes.
So if I understand your testimony correctly, it was a period, or a distance rather, of approximately 9.5 feet from which the witness, Lynn Marta, paralleled the steps of Rebecca Schaeffer down the hallway, correct?
Yes.
Now, the kitchen door and her apartment door are directly parallel.
I don't know how directly, but they're pretty adjacent to one another. I'm not sure if they're directly lined up, but they're pretty close to one another across from one to the
Martha's
other.
testimony wasn't that clear on this point to me because I didn't realize there was an issue, but I take it in the bedroom, she did not testify that she paralleled the...
It was my understanding that her testimony was that she paralleled the steps from this portion, the door jamb, to there.
So not in that case.
Yes.
No, I think the judge has already made up his
Now,
mind. I
I
don't
want
know
to
why
direct your
we're going
attention
through this.
at this juncture, at the reenactment, if you will. Your attention, I take it, was focused primarily on whether or not you could hear voices or hear any sounds from that area, correct?
Yes.
Your attention was not diverted to any other direction or conduct on the part of anyone who was present?
No, my focus was on what I was there to try to listen to. There were some distractions in regards to television and radio was on, but we were able to eliminate that.
Were you listening intently?
Yes.
How did you eliminate it?
Well,
by telling him?
No, we told the guy to turn it off.
All right.
Yes. We asked him to turn it off.
You've testified in this court before, haven't you?
I used to be a bailiff, Your Honor, right next door to you, Judge Garfinkel, Commissioner Garfinkel.
Now, just so that the record's clear, the way this diagram is of the entry door, it appears that this would be the outside of the apartment here on this configuration,
Yes,
correct?
sir.
But the door is actually inside here, is it not?
Yes, yes.
Yeah, looking at the photographs, it looks
Right.
like the door is recessed from the visibility.
It is, yeah.
By the way, I should say something for the record. Saturday morning, I drove by the apartment looking for you. I did not look at the apartment. I was looking to see if maybe you were doing the experiments in the morning rather than the evening. I was at Flores in Beverly buying a bicycle for my daughter's birthday. And my wife asked if there was a bakery around. The man said, yeah, right here at 3rd and Sweetser. And I said, Sweetser? Where's Sweetser? He said, the next block over. Flores is the next block west. So I drove down looking for you people. In fact, I glanced at the apartment just for, and I couldn't tell which of the two apartments that are somewhat similar it was. So I made noise. I just wanted to say that.
Oh, that's fine. Had we known, perhaps Ms. Clark and I would have driven down there.
Yeah, when I went out to buy the bike, I had no idea it was in the same neighborhood.
In any way, then, the court is correct that this is recessed and.
The photographs show that.
And the photographs show that as well. Now, Mr. Agee, when you, let me rephrase that, did you have an opportunity to make an observation of a person standing on this side of the glass door from the top of the stairs?
Yes.
And could you see that person clearly?
Yes.
The sunlight in the background did not reflect to such an extent you could not make out the features.
No.
Now, I should state for the record, Your Honor, that this was at a point in time different from what was testified to as the actual incident. But Mr. Agee, can you tell us, was it sunny outside?
Yes.
Was it bright?
Yes.
Did the fact that there was an alcove and that the door was recessed, did that seem to shade the sunlight somewhat from the background?
No.
In any event, you could see the person clearly, could you not?
What time of day was it? Again,
Well,
you made
was
an
it
observation of
5:30, 5:36, 5:30 or so?
something like that,
I
right?
think we arrived there at 4:45.
Yeah, and this was just before we went into daylight savings time,
Right.
or off daylight savings time, I should say.
Just one other thing. So every time we did this enactment, you could hear the voices and you could hear the door latch turning and you could hear the door opening clearly, correct?
Yeah, as far as every time, I'm 2 out of 3 times I was very clear on that. As far as the latch is concerned, there was one time that I may not have picked it up, maybe during the time when the music was going on, but I could distinctly hear the door opening and closing. as far as the door shattering because of the glass. But as far as the click is concerned, I couldn't possibly say that I heard all 3 times.
You mean shuddering?
Shuddering, not shattering, shuddering. But distinctly, I did hear the door clicking on 2 occasions. Yes.
Thank you.
Gross?
Yeah. So your vision is not impaired, is it?
No, ma'am.
You have perfect vision?
Well, perfect. That's 20/20.
Okay, well, you don't wear glasses, do you?
No, I wear contacts.
Oh, are you nearsighted?
Yes.
Were you wearing your contacts on that day? The walls of that apartment, sir, do you recall what they were?
They appear to be stucco type, yeah.
Did you notice any, in the hallways, any carpeting of any kind?
No, I recall it being wooden floors.
And did you notice any wall hangings like drapes or tapestries on the walls?
No, I don't recall that.
And the ceilings were, what kind of ceilings, if you recall, were they?
I don't know. I venture to say, I couldn't say, no.
Now, you recall at that time that we were actually doing the experiments was around 5:30?
Yeah, about that time, yes, ma'am.
Remember there was a fair amount of traffic on the street at that time?
Yes.
And you remember Lynn Marta was concerned about that as being different. The noise of the radio playing outside was ongoing through a couple of the experiments, wasn't it?
Yes.
But after we did it a couple of times, you had the radio turned off.
Yes, ma'am.
But the traffic noise continued.
Yes, ma'am.
When you did it with the radio on, were you able to hear the footsteps?
Oh, yes. Footsteps were very distinct, Your Honor.
And the voices?
Voices were very distinct, yeah.
Did you yourself ever attempt to manipulate that latch
No, ma'am.
and see what it was like?
No, ma'am.
So you did not attempt to determine whether it would be easier or harder at varying times to open the door?
No, ma'am. I made no contact with the latch.
Okay, out of the 3 times that you recall the experiment being done, twice you could hear the latch and once you could not.
Once I wasn't sure about hearing the latch. I couldn't, say for sure that I heard it or not. But I remember on 2 occasions I definitely was able to hear it. Yes, ma'am.
But on all 3 occasions, you did hear like the shuttering of the window in the door.
Yeah, when the door was like opening and closing, yes, ma'am.
Were you aware that on the first experiment when I walked down the hallway that I was not wearing shoes?
Yeah, I remember you told me that. I remember I asked you that. You said you didn't have your shoes on. Yeah.
God. And there was a female LAPD officer that did the experiment as well?
Yes.
Okay, she was wearing soft-soled shoes.
Yes.
Nothing further.
I have a few follow-up. Oh, I'm sorry.
The female officer, she was wearing standard police type shoes, correct? Did you see them? The blood.
Yeah.
Okay, well, describe. Let me rephrase, John.
She had rubber sole shoes on. Yeah, John.
Were they tennis shoes?
No.
Nikes?
No.
No, describe.
They were black shoes with rubber soles, similar to what a lot of police officers wore and what I had worn as a police officer.
And when Miss Clark was walking down, and when Miss Clark was walking down the hallway, was she walking softly or walking with definite, deliberate, hard steps?
I believe she was walking her normal way, which was pretty hard.
I have nothing further.
In order to get all the appropriate conditions under which the experiment was done, Ms. Clark, I need to know what you weigh.
On national TV, I was going to say this. Can we go in chambers, Your Honor? But let me ask one question of
of Investigator Agee. You've seen me walk around the courthouse before a few times, sir. Did you, in your opinion, did I walk any differently that day than you've seen me on any other day?
No. Well, I didn't see you walk, but
What you heard.
just the rhythm of the steps were very similar. Yeah.
Thank you. I have nothing further.
You missed it, then, sir. Anything else?
No, Your Honor.
I have to move this so I can see you.
That concludes the testimony that I wanted to put forth on that issue. I spoke to the court clerk prior to this session starting, and there seemed to have been some possible confusion with the introduction of exhibits last Friday when we had a different court clerk. It's my understanding.
The clerk left a note for for my clerk, something to the effect that I believe L and M.
I think she said M and N, but my understanding was we moved all the exhibits into evidence at that time.
My understanding. There was a little bit of argument by Ms. Clark, but I think everything was admitted.
Okay.
It was.
As long as we're clear on that, then.
Yeah, no.
I have one further request.
And if anything, if there's any, I'm not going to be a stickler for something somebody forgot to do. That'll be corrected immediately. Yeah, go ahead.
I would like to ask that People's 55 be admitted, which was the letter to Robert Cleves that I marked during the
That's the
testimony.
one that we haven't seen before. Yeah,
Right.
okay.
And also, I wanted to inquire of counsel as to whether or not the hospital charts pertaining to the admission to Tucson Psychiatric Institute had been marked as an exhibit for the defense.
It's Judy.
I
Crickets are
I don't believe that
Is that
we did. There was some discussion of that during the testimony of Dr. Park Deach, but I don't
But
believe.
I don't remember it being an exhibit. I just don't.
Nor do I.
Can we please
don't
not
think
talk
that was
about
an
that
issue.
again?
You want them?
I'm so over that thing.
I will bring down
My copy, if counsel does not have an extra copy of those.
Any objection to either of those, Mr. Galindo, either the third letter to Mr. Cleves or the Tucson hospital records?
No, Your Honor.
All right, they'll be received. And what do you want to mark them then?
I guess People's 56 would be I'm asking to admit
letter?
the hospital charts. People's 55 is the letter.
Okay, and
People's
56 will be
56.
charts.
Correct.
Okay, that's fine, and they'll be received.
Did you mark that already?
Yes, that's already.
I made a very valiant effort to listen to the tape of the Tucson police, and if I didn't have the transcript, which I had read previously in front of me, I would not have been able to follow it at all. I tried it in the car on the way home, and then I put it on my own stereo equipment at home. Very bad. I can follow it, I can get the tone of the voices, but were it not for the transcript, I wouldn't be able to follow.
Well, that was our point in asking the court to actually listen to the
tone of the voice?
Well, no, to pick out whatever the court could pick out, but I thought it was important that the court listen to the speech, the actual speech of Robert Bardo.
No, I'm telling you that in case you want to give me a tape with higher fidelity, if one exists, or anything else. But I have listened to it and was able to make out a lot of it. But I can't really say I heard. The questions of the police were fine. Defendant's voice was very bad. I'm also in the process of looking at the videotape, and I have now read all of the psychiatric testimony. All right. Is there anything further, Ms. Clark?
Yes, perhaps it would be germane to indicate to the court, I don't know if counsel would be willing to stipulate, but prescinding from the coroner's report, I would offer the stipulation that Rebecca Schaeffer stood 5'7", and at the time she was weighed at 138.
138?
Yes, and I am 5'6", and I weigh 120.
I don't stipulate to that last part, but.
Well, you can, wait a minute here.
No, that's
What did you
fine.
say you wouldn't stipulate to?
I would like to add
Get my documents
part of that stipulation that Mr. Robert.
No, I was just surprised that she was that heavy. You shouldn't look at Ms. Schaeffer.
I agree.
Yeah.
I was surprised too.
I would also ask as part of that stipulation that it include the fact that Robert Bardo stands 5'11" inches. I think that's important on that part of the
5'11".
That's fine. I would only
Weight is
indicate that.
irrelevant. Yeah.
That's fine. The weight is irrelevant in that respect. I was indicating that so council would appreciate the difference in our sizes vis-a-vis how well you could do our footsteps.
She was 5'7". All right. Okay, one thing here. What I did is make a very trivial subtraction exercise. The 13.7 on that diagram is the distance between what appears to be the western edge of the front door of Ms. Marta's apartment to the front door that we've been talking about, not to the, as indicated in that diagram, to the wall of the building, okay?
That's correct.
All right, I subtracted 9.8 from 13.7, and I got 3.9 as the distance from the bottom of the stairs to the door of the apartment house. Everybody agree? You've been there. Does it look like about 4 feet?
It was like 4 feet is what I.
Yeah, okay, fine. I just want to make sure that all the numbers that have been furnished to me indicate the appropriate, because I think that's important, how long the distance is between the bottom of the stairs and the door of the apartment.
I think we do have consensus in this because the officer was good enough to let us, well, actually, the officer was the one who used it, using a specialized type of.
One of those pedometer things?
Yes.
Right.
That they use to judge accidents?
Yes.
All right.
So he was pretty accurate, and he did the whole measurement from the top of the stairs going down to the stairs.
Okay, is that it?
That's it. As far as defense is concerned, you rest.
People rest?
People rest.
All right.
Or Fitbit.
So the next step is argument. Unfortunately, I still have to listen to the rest of that videotape, and there are a number of documents that I have not read, including the second Cleves letter, the Tucson hospital reports, and I'm going to go through the exhibits. So can we plan on arguing tomorrow?
I believe you had indicated Tuesday afternoon because of.
Tuesday afternoon is fine.
That's what I would prefer.
How long do we, I would like to do all of the arguments
I agree.
Tuesday.
Oh, yes.
Yes.
As I think I've indicated previously, my argument will be extremely brief.
All right.
So,
Do you know whether you're going to make an opening argument yet?
don't know.
Don't know? Okay, that's fine, reserve. I'm just trying to figure out time so that we're sure to get it all done tomorrow. Okay, so then we'll put this over to 1:30 tomorrow afternoon. Okay?
Thank
Is
you.
the court anticipating the ruling tomorrow?
I would think, but I need to review a lot of material, and I am anticipating making a ruling tomorrow, yes.
Okay. It has been a long day, hasn't it? I've lost a bunch of people because everybody got tired of deets. Okay. We'll do closing arguments tomorrow and the verdict tomorrow. And then we will be done with Robert John Bardo. And tomorrow, oh, no, we won't. Because we've got Walsh's, my brain is fried. Walsh's sentencing hearing tomorrow. We will not be done with Bardo tomorrow. And then Friday, I will be streaming, but I will be streaming from Epcot. I will not be streaming from here. For the Festival of the Holidays, I will be streaming. They have storytellers from the different countries. Norway has a barn Santa, a mischievous barn Santa. Père Noël from France, Father Christmas from England. Trying to remember. There's others. I just can't think of them all now. There is also Christmas cookies from other countries that I will be trying. And if it works, I'm not done talking, Wiggles. And if I am successful, I will be streaming the candlelight procession, and Gary Sinise is going to be the narrator. So that will be on my Disney channel. And I will put the link in this chat tomorrow. So if you really love me, you'll be there. But that's Friday. I will be here tomorrow at 8 o'clock. So I will see you tomorrow. Remember, be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys.